Telephone off, please. Almost one. I mean, almost two. 30 seconds. No, we're not ready yet. Take a seat, please.
All rise. The Justices of the Appellate Division, Supreme Court, First Department. Hearing, hearing. All persons having business with the Appellate Division drawn near. If your attendance, ye shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. I will begin with the call of the calendar. Most of you know the drill. There are 6.5 hours of argument time requested. So I'm going to ask you to pare down your requests to the time you actually need, not the time that you want. Understanding that the clock is for you, not for the court. So if the court has, because you have been arguing so brilliantly, additional questions, we keep going, okay? So that being said, People versus Francisco Alsina. Okay? 5 and 1 and 5. Beton Court versus Burnside Muse. 6 and 1 and 4. Jane Doe versus Black Rabbit 19.
5 and 1, Your Honor.
Okay. Oh, I'm sorry. F. Dana versus V. Derek. Stay up is a submit. Jane Doe versus Black Rabbit.
5 and 1, Your Honor.
5 and 1. All right, let's do 4 and 1 and 3. People versus Clarence Seabrook. Submitted. Duran versus East 185th Street. Submitted. People versus Cisse is submitted. Padilla versus Estate of Larmet.
3 and 1, Your Honor. For plaintiff.
Okay. Do you have a cross appeal? No. Then you don't have rebuttal time. So 3 and 1 and 4. People versus Anthony Gordon. Submitted. Fields versus General Conference.
5 and 2 for appellant.
Okay. Oh, okay, that's right. We have heard from respondent, he requests 10 minutes, 5 and 2 and 6. Okay, Rak Lafayette Associates versus Sturm.
5 and 1 for appellant.
Okay,
4 for respondent.
5 and 1 and 4. People versus O'Neill Powell, submitted. People versus Taj Underwood, submitted. Ace American versus Con Edison. And I understand Furman versus Lexington Avenue has withdrawn their appeal. Are you here?
That's correct, Your Honor.
Okay. Now, we received the transmission of your notice of stipulation to withdrawal was sent at 5:50 p.m. Are you telling me that this case was settled at 5:49? And so why did it take until 5:50 p.m. to notify the court? Do you understand that on a double appeal, my colleagues are combing through a voluminous record, and it is disrespectful and discourteous to the court to not advise the court as soon as practical? As soon as you know, we should know that the case is resolved. Please make sure that your firm knows this going forward. It is not appreciated.
Yes, Your Honor.
Okay? All right. So Ace American versus Con Ed, I will hear requests for time.
Appellant integral, 5-1.
Okay?
Respondent Con Edison, 5 minutes, Your Honor.
5 and 1 and 5, thank you. Mikelo versus D.E. Shaw and Company.
Appellant requests 6 and 3, Your Honor.
6 and 2 and 6. People versus Alvin Suber.
Good afternoon. Appellant request 5 and 3.
Did you make a request? According to my sheet, you made no request for time.
I apologize.
Okay, were we advised that that was an error?
I'm sorry.
Were we advised that that was an error? As late as this morning, when I received the calendar, there was still a 0 time request for you. You have to check this, and when there's an error, you need to advise the court so we know, okay? So I will give you 3 and 1. How much?
Respondent requests 3 minutes, Your Honor.
3 and 1 and 3. Hart versus Scaglia.
Respondent here for 5-minute DDK.
Okay, looks like you scared away the appellant. Do you wish to argue or do you want to submit?
I will
3
3 minutes.
minutes, you got it. People versus La Manara Ba.
Appellant request 5 and 2.
Okay? 5 and 1 and 5. It'll probably be 5 and 2, but you know. All right, Stafford versus EV Transportation is a submit. Kalodziejski versus Genmar, I know I mangled that name, that's a submit. And Fernandez versus Suffolk County Public Administrator is a submit. First case on the calendar, People versus Francisco Alsina. You may proceed.
Good afternoon, and may it please the court. Alexandra Mitter on behalf of Appellant Francisco Alsina. Now, there are significant problems with the prosecution's purported proof against justification here, and I will be talking about those. But where I'd like to start today is Mr. Alsina's sentence. Because if this court doesn't reverse Mr. Alsina's conviction, which it should at a minimum reduce the 35-year to life sentence given to this 23-year-old. Running the maximum murder sentence consecutive to the other charges here was excessive. It was unduly harsh to tell a 23-year-old that they'll be in prison for at least a decade longer than they had been alive at that point. All the more so here because this was Mr. Alsina's first interaction with the criminal legal system. But the judge, in effect, threw the book at him. As it stands, he will be nearly 60 years old when he first goes before the parole board. And all we're asking this court to do, if it doesn't reverse Mr. Alsina's conviction, is to give him a chance to go before the parole board sooner. Ultimately, it will be up to the parole board. Yes.
Counsel, didn't one person die within a minute being
Yes.
shot? And didn't the surviving victim end up with an ileostomy, so he's got a bag for the rest of his life?
There's no doubt that.
And didn't the defendant also threaten his girlfriend at the time that if she spoke to the police, he'd come after her and her family?
We dispute the latter fact, but there's certainly no question that someone died and someone was seriously injured. But this all happened in an instant, even under the prosecution's version of events.
The crime didn't happen in an instant. I mean, there's a lot going on before the shootings actually take place.
Absolutely, and I think, Your Honor, that's a wonderful segue to talk about what actually happened here, because the proof here at trial was simply not enough to disprove justification beyond a reasonable doubt. This isn't an affirmative defense. We start from the position that Mr. Alsina was justified, and we ask whether the
How?
how
How was he justified in shooting 2 people within close range that didn't have a gun on him? How?
because under the law, the prosecution has to put forward proof that Mr. Alsina was not justified. The only evidence that even theoretically goes to what happened is Lamboy's testimony. And it's simply not enough on his own. Mr. Lamboy's testimony.
Why? Why isn't it enough on its own?
For a variety of reasons. Number one, it's not corroborated by absolutely anything at all. The only thing respondent points to as corroborating evidence is the surveillance footage, which I understand this.
Wasn't there also testimony from witnesses who arguably weren't even involved in whatever dispute, drug transaction that was happening that supported or I guess negated whatever justification defense you're asking the court to consider?
I disagree with that characterization, Your Honor, for two reasons. First, the video shows that the vast majority of the argument that happened outside of the McDonald's, which I believe is what you're referring to, happened while Mr. Alsina was not there. And so the idea that Mr. Alsina, who's up the block and in a car under everyone's version of events, I mean, that bit is undisputed. The idea that he should be responsible for the conversation that happens there, I think, is not fair. And I think
Mr. Quiroga see the defendant return with a gun in his waistband?
Pardon?
Does Mr. Quiroga see the defendant return with a gun in his waistband?
He does indeed, and there's no dispute that Mr. Alsina had a gun. He concedes that he had a gun. It was a poor decision on top of a poor decision on top of a poor decision. But making bad decisions doesn't negate a justification.
I mean, you say there's no corroboration, so, you know, it's undisputed that he had a gun. It's undisputed that we have two shot people. There's, your client, I think, wants to say he was attacked by someone with a knife, although the knife is never found, and there's no corroboration of that.
I would say being armed in a justification case where the premise is that someone has died does not corroborate that there was no justification. In almost all justification cases, the defendant here is going to be armed.
He says that the reason he shoots these people is because one of them lunges at him with a knife. One is shot and is dead instantly. The other one is shot in the stomach and passes out before he even gets outside of the train station. So if one of them had a knife, it would have been found since a off-duty police officer responds to the scene immediately, correct? And doesn't find a knife.
I don't think the
Which would be the only basis for a justification. So tell me what evidence other than your client's word is there to support that he was defending himself against an attack, which would be the only reason he would be justified in shooting.
I think the ballistics and the sort of position of the bodies completely corroborates exactly what Mr. Alsina said happened. The flight path of the bullets is on a almost flat line, whereas Mr. Quinones was alleged.
Was it? I thought that it was on a upward trajectory.
I mean, upward trajectory can mean a lot of different things. If you look at the...
Does it really mean a lot of different things, or does it mean upward, meaning going up?
I'd be
trajectory.
I'd be happy to show Your Honor the autopsy photographs. I have them here if that would be helpful. The upward trajectory is at most a millimeter difference from the entry to the exit. It's not like we're talking about here, which is, I think, what would be expected if Mr. Alsina, who is 5'4", shot someone who is 5'9" several steps up the stairwells. And also, I just like to I see my red light is on, but just to circle back.
You can do that on rebuttal.
Not a problem.
May it please the court, my name is Sheila O'Shea and I represent the respondent on this appeal. I'd like to start with the sentencing point. I don't dispute for a moment that 35 years is a very long time to be sentenced to prison. However, I submit that the judge had an ample basis upon which to mete out consecutive sentences. There were two separate victims, as the court has recognized. One died almost instantly. The second was seriously injured, could have bled out had he not been rushed to a hospital and been operated on immediately, and is left with a lifelong impairment of an ostomy bag. And as the judge noted that he was facing perhaps lifelong additional surgeries, it's not even clear that procedure could in fact be reversed. The judge also talked about the anguish suffered by the decedent's family. The decedent's daughter actually gave a victim impact statement in sentencing, talking about the pain and anguish her family had suffered as a result of the murder of their father. The judge noted it was painful to listen to that statement, and again, that they would be suffering the emotional repercussions of this murder for the rest of their lives. A few other things.
Why don't you address the justification defense argument being raised by defense?
I disagree with my adversary that there was no corroboration to Lamboy's testimony. There was ample corroboration in the form of Quiroga was the oil delivery man who saw the defendant with a gun in his waistband as he was walking back to the McDonald's. He also overheard a group of men arguing outside the McDonald's. Basile, I think most importantly, was one of this group. He heard a sound that sounded like what he characterized as pre-cocking of a gun. This is someone who'd grown up with guns and was familiar with that sound. He also believed that what the defendant was fiddling with in his hoodie was a gun. So he retreated into the McDonald's at that point and announced to the customers, I think, he has a gun and they're going to the subway. Detective Brower made the same sound of I can't imitate it here, but made the same sound of the pre-cocking sound that Basili himself had made and explained that the 9mm gun that defendant had used would have to be racked and would have made the sound that Basili had made for the jury. And most importantly, I think the surveillance video clearly shows the defendant reaching into his waistband with his right hand as he's leading the three men to the subway station. 9 seconds later, the shots have been fired. The victim is dead, and Lamboy himself has been seriously injured. So I think the fair inference from all of that is that the defendant was preparing to shoot the victims before he even walked toward the subway, which undercuts his justification defense, which was that he only pulled out the gun because a knife was wielded against him by Lamboy in the subway. And would you like me to address any other points, or?
That's up to you. It's your argument time.
Would you like me to address the false testimony point, or if the court has no questions, I'm happy to rest on my brief.
Thank you.
Thank you.
All right, counsel.
Just briefly, the knife, I know we spent a bit of time talking about that. This was a justification defense asserted in defense of a robbery, not in defense of potentially fatal force being used against them. So I want to be really clear about what the justification defense was here. This was not one that strictly required the presence of a knife on the other
Except
side.
that part of his justification, it was that he was being lunged at with a knife, and then immediately after this incident, when the off-duty officer gets on the scene, there is no knife. So then that lends to credibility, which the jury is free to disregard.
I take your point, Your Honor. I just wanted to make the legal basis for the justification defense here clear. The other thing that the video shows, since respondent is so reliant on this video, shows that Mr. Alsina and the decedent, Mr. Quinones, were never in the same place at the same time. When Mr. Quinones was inside the McDonald's, Mr. Alsina was outside the McDonald's. When Mr. Alsina was in his car, Mr. Quinones was outside the McDonald's. Yet we are supposed to believe that Mr. Alsina shot this man he doesn't know from Adam instantaneously. It simply doesn't make sense, and it really goes much more
Counsel,
to this.
but where did the shooting take place? It's not at the McDonald's. It's at the subway station.
Right, and Mr. Quinones arrived at the subway station. The video is very clear. Mr. Quinones arrived at the subway station after everyone else.
So you're saying Mr.
Alsina.
Alsina, no. The victim, you're saying that was an innocent bystander?
No, I'm saying Mr. Quinones was not an innocent bystander. He was part of this drug transaction gone wrong. And the idea that Mr. Alsina shot this person for no reason whatsoever doesn't make sense. What makes sense is that he was interacting with Mr. Alsina in the subway station in the moments before this shooting happened, which is exactly what Mr. Alsina described. It is not what Mr. Lamboy described, someone being up on the stairs and getting shot. That's simply not consistent.
Except it defies the forensic evidence.
It does not defy the forensic evidence.
It sure does. It said it was on a upward trajectory, and you can minimize the extent of that upward trajectory, but there was no evidence that contradicted that evidence. Thank you.
Thank you, Your Honor.
Beton Court versus Burnside News.
Good afternoon, Your Honors. My name is Robert Von Hagen from Molad, Spitz, and DeSantis for the appellant. My client, the landowner in this case, and the tenant, Empire, are in total agreement that my client is out of possession, that they had nothing to do with the plaintiff's work, and that they had no responsibility for this hoist mechanism existing at the property. Any assertion that the hoist was somehow...
You inherited that tenant.
We did. We inherited the tenant, and
the apparatus inside the building.
That's exactly right. We did not design or build this building. The tenant had used it for many years as a tool within the tenancy, and they continue to do so. My clients actually testified that they did not even know that the hoist was in there. That's testimony from both Mr. Zavudis's. So any assertion that this is somehow under our control is really defied by the evidence. The other thing here is that any assertion that the hoist is somehow structural is belied by the evidence, and it's also roundly rejected by this court's precedent in the Ram case, the Mejia case. They go on and on. I cited many of
Counsel,
them.
there were no violations here, am I correct?
There's no violations whatsoever. There were no notices of violation.
Are there any statutes or regulations that are applicable where you have a hoist that not only ascends and descends, but also moves laterally?
None that have been raised by the plaintiff, none that have been proven, none that my client was aware of, certainly. No actual notice of any such violation.
As the building code provisions that were cited have nothing to do with anything that moves laterally, and in fact, they dealt more with fire enclosures, am I right?
That's exactly right, Judge. I mean, we have to go through that down the rabbit hole of referencing different codes, but if you go to Article 2 or Chapter 2 of the Building Code and you look up the definitions of these different elements, there are different terms of art for hoistway, shaftway. And when we follow that rabbit hole that the plaintiff's expert has kind of contrived, we get to regulations about fireproofing, which really the whole purpose is if there's a fire on the first floor, there are enclosures to prevent the fire from going up a skyscraper and burning the whole building down. This is a two-story premises where there's one opening. There are not successive shafts. There are not, there's no need for an enclosure. More to the point, Judge, the place that...
Are there elevators?
There are no elevators. That's undisputed in the record. There's a stairwell, so that any worker that is using this particular device...
Does the record reflect the dimensions of the platform? Because when you look at the picture, it looks pretty small.
It is what the picture shows. I mean, there are other points of reference in the photograph where you can kind of size it up and get the relative size of it. You can look through the garage and actually try to find it, and it's really not locatable. My client's testimony is that they went to the mouth of the garage, and then further than that, didn't impede on the tenant's business. It's essentially their property. We're out of possession.
And counsel, amplifying just a bit on what I asked you before about codes.
Yes.
Does the industrial code reference any type of apparatus that would move laterally as opposed to vertically?
None that was raised by the plaintiff, again, and none that we were on notice of, none that were violated. Not to mention the industrial code was dealt with already by the lower court in its earlier decision dismissing the 240, 241-6 claims, and those industrial code provisions were necessarily included in that determination. So there was no code violation, Your Honor. And the ones that were raised by the plaintiff were really cobbled together and don't apply at all.
Thank you.
Thank you, judges.
May it please the court, Vincent Chirico for the plaintiff respondent. Justice Suarez down below looked at this twice. So aside from the renewal question, the fact remains that it was carefully analyzed and 3 issues of fact were found. The first one was the question whether the defendant was the out-of-possession property owner. The second is whether there's any statutory...
The lease itself, in regards to what the property owner's obligations were, it referred to repairing the facade, the sidewalk, and the roof, not necessarily anything interior, and particularly not this hoist mechanism that we're talking about, right? I mean, you're not going to stretch that into what the lease...
Well, Your Honor, at page 725 and 726 of the record, the lease also reserves in the defendant the right to change the arrangement and location of various internal equipment, including elevators.
The elevator. And we're not talking about the elevator, so that provision is irrelevant.
Well, Your Honor,
No, the provision is specifically about an elevator. Am I wrong about that?
It is, Your Honor.
Okay, so it has absolutely no application to what we are talking about here.
Well, the expert that submitted an affidavit in this record indicates that the elevator section does in fact apply.
And I'm telling you that the contract says what it says, the statute says what it says, and this is not about an elevator. So your expert's opinion notwithstanding, an elevator is an elevator is an elevator. And this was not an elevator.
Well, Your Honor, with due respect, the lower court held that there was an issue of fact on that issue based in part
And that's
upon
why
the
we're
expert.
here.
That's why we're here.
Counsel, let's make it easy.
Yes.
So 3002.1 of the building code, cited by your expert, refers to hoistway enclosures. There is no enclosure here, or is there?
There is none.
We're referencing a laterally moving mechanism, correct?
It's also a mechanism that goes up and down from the basement
Yes,
to the
but
first
the
floor.
accident occurs on the horizontal operation of the equipment, not in the vertical operation, correct?
It did occur during the lateral movement, but the hoist does go up and down.
Okay, so fire resistance referenced in 3002.1 of the building code is not relevant or related to lateral operation or a lateral movement of that equipment, am I right?
That's correct, yeah.
Okay, so let's move on to 12, what is it? 12 NYCRR 8-1.16 of the Industrial Code. It references fireproofing materials to be used in all hoistways. Did the accident concern fireproofing?
No.
Okay, let's move on to 12 NYCRR 8-1.41. Freight elevators shall be enclosed on all sides. Is this applicable here? Is this particular section of the applicable here where the relevant portion is outside of the enclosure?
I don't understand the question, Your Honor.
12 NYCRR 8-1.41 says freight elevators shall be enclosed on all sides. Did this happen within the enclosure or outside of the enclosure?
Well, it happened in both. The items that fell, the elevator the hoist and the chain that broke happened on the outside of the elevator, and material fell from the inside of the
What
hoist.
elevator?
The hoist.
Okay.
There is no elevator.
In regard to the particular code that my colleague is referencing, the plaintiff's expert opined that the absence of an enclosure for the hoist elevator allowed it to move forward toward plaintiff and strike him. That the absence of the enclosure somehow caused it to strike him. I mean, if that's not conclusory or speculative, I really don't know what is, because it doesn't even go on to explain how so that would make it applicable here.
Well, to the extent that the lateral movement and the material that fell out of this hoistway was on the inside, I believe that Mr. Coniglio is correct, that it is applicable, Your Honor.
Thank you.
Thank you.
You have 1 minute.
Thank you, Judge. As briefly as I can, Mr. Coniglio did not inspect the premises. The photographs that he looked at, which are in this record, do not show the area where the accident happened. They do not show the opening between the first floor and the ground floor. The notion that he has any foundation to opine in this case, it's really not a credible assertion.
Is there any testimony or is there anything in the record that indicates the distance between the failure of the hoist and the enclosure?
Mr. Betancourt himself testified that him and his coworker took several steps away from the opening, and that he was moving it at a vertical, in a horizontal plane when the incident occurred. So there's no question. I'm not sure how counsel can assert that this accident happened in two places at once. It happened on the ground floor after the device had started to be moved towards the garage door. This is not an elevator, as Your Honor points out. And back to the lease provisions, there is absolutely nothing in the lease obligating my client to maintain this hoist, the operation of the premises and the safety of the people who were there.
Under the lease, you were responsible for the facade.
The facade, which we took responsibility for in an earlier project that...
You repaired it.
Yeah, exactly right. And then there's no question that we were off the premises months before this accident happened. So the custom and practice is absolutely in line with the terms of the lease. And our witnesses say, we never went inside the building to take care of this. We only went up to the garage doors because it's Empire's business. It's their tenancy. They have quiet enjoyment. It's the underpinning of the out-of-possession.
Under the lease, you all, may I? Under the lease, you were also not you, but your client, was also responsible for the sidewalk.
That's right, Judge, yeah.
Thank
Did
you
this
so
happen
much.
anywhere on the sidewalk?
No,
Thank you so much.
thank you, Your Honors.
Jane Doe versus Black Rabbit 19. You may proceed.
May it please the court, Daniel Zalkowitz for the appellant Jane Doe. Black Rabbit 19, Black Bun, Fake Spear 999, Hurtful Sloth. That is certainly probably some of the strangest respondent names this court will see, but that's because those are the social media handles, the websites created by the defendant Maxwell Hong in order to disseminate Jane Doe's intimate images over the internet.
Everybody would agree that all of those handles were the handles of Maxwell Wang, right?
Correct.
Okay. So
So
the
how?
question is whether or not there's jurisdiction over him.
Correct. And we concede under traditional notions of jurisdiction, 302A, you would not have jurisdiction over Mr. Hong. Therefore, under the civil rights law 52B, sub 5, there is a special jurisdictional language contained within that.
Right, and under that particular section, when we go down to subsection B,
Yes.
it talks about being hosted or transmitted when it talks about jurisdiction,
Yes.
right? Because this particular section 5 talks about websites. And when you go down to subsection B, which talks about the jurisdiction for those particular websites, we're talking about hosting. I mean, the language is right in there. I don't know how you want us to extrapolate that to an individual person when we have a particular section for that. Right above that, in subsection B, 52-B1, it talks about what happens with individuals when they do this kind of particular action.
But it doesn't. It talks about, I apologize. It's not that it doesn't. It talks about more of a general sense of this sort of non-consensual pornography. Intimate
When you're
image,
saying it, are you talking about,
section 1.
are you talking about, okay, so that's as to section 1, but the,
So
but
if someone
you're asserting
utilizes,
jurisdiction under section 5, how do you claim that these defendants come within
because
a jurisdictional ground set out in 52-B5?
a website does not simply transmit images from point A to point B. There has to be someone behind the website
What
to
is
do
the
that.
basis for your claim that these people, that these defendants, which, as you said, are all really Mr. Huang, are a website? They're not a website, he's a human.
But he's utilizing a website to transmit the images. He
That's
utilized
not what section 5 is about.
But it-
Section 5 is about a website. He's not, and how to get jurisdiction over a website, but he's not a website,
what
right?
does it mean to be a website ultimately?
His use of a website doesn't make him a website.
No, but
his use of a website through an account doesn't mean he has a website. He is utilizing an aspect of a website, but he himself is not the website owner.
But he is affirmatively creating a page on a website.
Right, an
then
account
using
page.
that page
How does an account page equal I am now a website owner?
because there has to be.
What case law says that?
There is no case law to that.
Hmm.
Now,
So then
conversely, there's no.
We'll turn to the statute itself, and we'll talk about the language, and we'll talk about website means. And when we're talking about that, we're going to look towards what's the ordinary use of that word.
Yes.
I don't know, and maybe you can point me to where the ordinary use of the word website means an individual.
The law, as it's written, recognizes that non-consensual pornography exists. There is.
But counsel, I don't think that you're answering the
Well,
question.
I'm getting.
If we look at statutory construction, we have to look at the plain language. And if website was meant to include the user or the operator of the website, arguably that language would have been included there, and the term individual would not have been used in the provision that is above that, which is expansive, which is the B1 provision.
But if I can share someone's intimate images through text messages, through printing them out and turning them to someone, and that will violate Civil Rights Law 52. That relates to the dissemination of images, and that's what an individual does.
We don't disagree with you that the dissemination of these images was an outrage. An absolute outrage. Okay? No question about it. So did your client have a legitimate claim? Yes. The issue before us is, did you bring it under the right section? Did you commence the action in the right jurisdiction?
Yes.
Those are the issues before the court. So I want to be clear for you and your client that the court is not at all suggesting that the publishing of her intimate images by her ex-boyfriend was anything less than an outrage, okay? That's not the issue before the court, okay? And when you get back, as you see your red light is on, you'll have some time. I'll give you an extra minute since we interrupted you so much, okay? Counsel.
David Lowe for the respondents. May it please the court. Judge, we are not here to defend the actions of the respondent. We're just focused on the issue of personal jurisdiction. And
Very smart, because it's indefensible.
Judge, Judge, he has a mother, he has a father, he puts his pants on just like everybody else, and he's not a rapist, he's not a murderer. He's entitled to a defense under the circumstances. And
I agree. I don't disagree with that.
And we recognize the court's outrage in connection with the behavior of the respondent. In terms of what the court has addressed.
Your case is just that this defendant's got nothing to do with New York.
That's right.
And therefore, there's no jurisdiction over him.
Absolutely, Judge. And that's our essential point here. And if the court has any other further questions, we're happy to raise them.
Do you disagree with the questions that have been asked with respect to the section that was utilized to bring this action, that clearly, under the section claimed, your client does not qualify as a website?
Judge, we would refer the court to Judge Guzman's
That was a very
decision.
easy question.
That was a softball if I ever gave one.
Judge, we absolutely agree with it. 52B1 refers to individuals specifically as being the defendant to respond to any particular cause of action relating to the dissemination of such images. Subsection 5, however, refers specifically to a website which hosts or transmits those said images going forward. And we certainly agree with the lower court's decision when we ask the court to affirm.
Counsel, would you speak briefly to 5B of the statute, which talks about a resident of this state?
So, Judge, we want to point to record page 40 and record page 69, which do refer to the fact that it's our position, and I don't think it's undisputed, that the plaintiff appellant was a resident of the state of Texas at the time this alleged behavior occurred. So that's a further position that we're taking with respect to why jurisdiction doesn't apply. And the wording of 52B refers to conduct that occurred at the time as a basis for personal jurisdiction. We don't disagree that the plaintiff appellant may be a resident of New York at this time, but in terms of when the tortious behavior occurred with respect to my client.
I thought that the further problem was that at the time that she instituted the action, she was not yet a resident of New York.
That's correct.
And it seems to me that that's the more important issue rather than the acts of which she complains of she was a resident of somewhere else. Because when she filed the complaint, if she had actually been a resident here, she would have a stronger hand.
Judge, you're 100% correct. I stand corrected. That's exactly what our argument is going to be.
Okay. Thank you.
Thank you, Judge.
All right. And I am going to add a minute to your time, okay?
I'll speak fast then.
All right.
One, she was a resident of New York when she instituted the action. There was nothing in the record to indicate otherwise. The complaint itself.
When she served the summons?
She was, correct.
Where in the record does it show that? I did.
But,
well,
sorry,
let me phrase it this way. I couldn't find that in the record. If the record doesn't show that she was a resident at that time. What is that? What is the implication of that?
It was contained within the reply brief, Your Honor, in the
In the
complaint.
brief? I'm
The
sorry.
reply brief?
A brief is not where you establish
I-
the facts, counsel.
Record
When I talk about the
19.
record, I'm talking
Record
about-
19. We addressed that argument in the reply brief.
No, I understand, but a
What's the
brief doesn't-
proof?
A brief doesn't establish the facts. So if the only basis for your claim that she was a resident at that time is a brief, then you have a problem.
No, it's in Record 19. It's in the complaint itself that at all relevant times she was a resident of the state of New York, a resident of the county of New York, state of New York.
Did she move to New York before the petition was filed?
Yes.
So she was actually living here at the time
was-
that the papers were?
She was a resident at the time the summons with notice was filed.
But the summons was filed before the complaint.
Correct. That's correct.
So what in the complaint establishes that she was a resident of New York at that time?
Again, in the actual complaint itself, it says that complainant states she was a resident of the county of New York, state of New York. It should be contained on the record, page 19.
So in that situation, she's made that assertion, and then the opposing party is questioning that and indicating that she's probably a resident of Texas. What is then your duty at that point? Do you have to establish through some sort of documentary evidence proof that she was in fact a resident of New York at the time she filed the summons and complaint, or you don't have to do anything because you've asserted it and that's enough?
That was not an argument that was actually raised as to where she was at the time the complaint was filed. It was an argument that he claimed when I knew her at the time she was living in New York, in Texas. So I understand that once the burden would shift to us to show residency, but they didn't actually assert that argument in the lower court. They more posited it to the court that we don't even believe that she's necessarily a resident of New York. Going back to the court's questioning as to, I think the fundamental issue becomes what is a web page? If I create a Facebook account, and on my Facebook account,
No, I'm sorry. The question is not what is a web page. The question is whether your client, whether the defendant constitutes a website under the statute. That's the issue.
Yes. And if
So him having an account on a website doesn't equal he is the website. Right? So if he has a Facebook account and he posts these pictures on Facebook, Facebook is the website and he's not the owner of Facebook. He is the owner of his web page, of his account page, but that is not a website. That is a page on a website.
And just to add to that, the language of the statute then goes on to talk about hosting, right? And hosting is where we will look to determine whether or not what is a website, right? We're going to take these words for their plain language if they're not defined in the statute. He's not hosting the website just by having these username handles.
But there are two. It's hosting or transmitting. If I'm utilizing a website to transmit, a website is transmitting. I'll use the exact language, images.
It doesn't say uses a website.
It
says where a website hosts or transmits.
But a website transmits. And how does a website transmit images? Someone uploads the images to the site and they are then sent. Who is the one doing that? It is not Facebook that is uploading the images. Take it a little bit back in time. I know we do a lot of defamation work. If I create a blog online and I'm sued for defamation based on the blog.
But the blog is your blog.
But so is the Facebook account.
No,
use
Facebook account, look, if you create a Facebook account page, you have a page on Facebook's website.
And in order,
The website still belongs to Facebook. They can shut you down, they could put you up, etc. He does not control Facebook.
but he controls what's transmitted on that page.
Okay.
He's the one that physically has the ability to send a message.
I don't disagree with you on that, but I don't think that's what the statute says.
The problem is the statute in and of itself is unfortunately not as clear-cut as I would like for it to be.
Well, that happens a lot.
It does,
Thank
which is
you.
why we're here
I have
today.
one more question.
Yeah,
You said
my
that-
colleague has a question.
You said that on record 19, it said that the plaintiff said that at all relevant times she lived in New York. That's not, unless you have a different page, record page 19, my record page 19 says she is a resident of the county of New York, but that was in 2022, 2 years, a year and a half after the summons was filed, in 2020. So that doesn't show that she was a resident at the time the summons was filed.
I apologize. I only was using the selective quote that I had. It is my
Selective quotes are
understanding.
dangerous, counsel.
And it's not meant to mislead the court. It is my belief, understanding she is a resident of New York.
But if
Was
it's
it all?
not in the record, we don't know that.
I
And
understand, but that was, again, not an argument that was specifically raised by them. It was just sort of a point they tried to throw out there, saying that she, in the lower court, otherwise we would have specifically attached her driver's license, her lease, and items like that to show that she's a resident. Same way when you do with election law work.
Thank you so much.
Thank you, Your Honor. Thank you, Court.
Jose Rafael Padilla versus the estate of James Clayton Larmet.
Good afternoon.
Good afternoon.
Stephen Weiss for the plaintiff appellant. I won't obviously repeat what's in the brief, but the court below, the surrogate, based her decision on dicta in the Aaron case.
right, but I agree with you that that was dicta in the Aaron case. However, it was not dicta in the Court of Appeals case, matter of American Committee for Weitzman Institute of Science, a 2008 Court of Appeals case. So I noticed that too about Aaron, and I went and chased it down and realized that that is good law, even though it was only dicta in Aaron. So given that that is good law, the statement that the motion court relied on, where do we then go?
I believe that also in the case that Your Honor just cited, it's that case was based on undue influence, and the reason for the decision in that case, from my reading of the case, is that the court found there was no undue influence. It was not based on the lack of a promise to relinquish the right to change one's will.
But let's talk about that. Based on this record, how can you argue that this decedent ever expressed a relinquishment of his right to change his will going forward? In the record, I see at least 3 different changes. And just prior to his death, he wanted to change it again to include his nephew. So all of those facts lead to the opposite conclusion, that he did not at all relinquish his right to change his testamentary decisions.
I agree with you. He never gave up that right. But the question is, why would he be
Then if he doesn't give
required?
up the right, how can the plaintiff hold him to what he said?
Well, he may, there's no dispute as to the writings, there's no dispute as to the videotape, there's no dispute that he intended.
Actually, the videotape was never in evidence.
never in
It was not
evidence.
part of the record in front of us, so let's not talk about the videotape, counsel, please.
There's no dispute as
You
to
want
any of
us
the
to write
facts.
the will, but he never gave up the right to write the will himself.
No, but where is there a requirement that he give up his right to change his will? If I make a
In this situation.
In the Weitzman case, in the second paragraph of Judge Saparek's decision, she says that quite clearly.
But that's dicta, because
No, I'm sorry, in Weitzman, it is not. It is a holding. We conclude that the correspondence presented here fails to satisfy the EPTL requirements because it does not indisputably demonstrate decedent's intent to renounce her right to freely execute a subsequent will during her lifetime. That's a holding if I've ever seen one. It's right front and center.
correct, except there's nothing in the EPTL that requires that the testator give up his right to
Counsel,
change his
you're
will.
trying to argue against a Court of Appeals holding. We are not going against a Court of Appeals holding. So you're going to have to come up with something else if you want to win the day.
Okay.
Okay?
Well,
And the Court of Appeals has spoken very clearly on this issue.
but the Court of Appeals decided that case based upon undue influence. The case that Your Honor is citing, it didn't decide it on the basis that, if you look at it logically, the giving up the right to, if you make a promise to give a bequest to someone, and then you breach that contract, whether or not you gave up the right doesn't change the cause of action. Does that
It
put
does under our case. Under the Court of Appeals case law, it does. But I'll give you time on rebuttal.
to reply? Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. Megan Gregg for Hughes, Hubbard, and Reed for the estate of Larmet. I mean, our case is based on the Weitzman decision. The law in New York is clear that you have a right until you die to change your will, and you have that right unless you expressly revoke it in writing. We don't have an express revocation in writing here. The claimant's argument that that revocation makes no difference is just contrary to the New York Court of Appeal, or the New York Court of Appeals decision.
Look, let's be clear that the case law requires us to follow the case law. But there's also no question in my mind that this decedent wanted this man to have some money. That he did not complete it the way it needed to be done so that he could actually give this gift. I agree. But there is no question that this man selflessly gave of himself to someone not of his family, took care of this elderly man when he needed him the most, okay? So I don't want to hear any aspersions cast on this. This man did what we want all of our neighbors to do, to take care of one another, right?
We're in
that
complete
we
agreement.
can't do anything about it because the law ties our hands is what it is. But I give high praise to the way that this gentleman took care of the least of these.
We totally agree. The problem is that to find for him would unfortunately require disregarding the law.
I agree. I agree. Thank you. Counsel?
I just briefly looked at the matter of American Committee for the Weitzman Institute, and it's my reading that this decision was based upon a finding that there was no undue influence, and then when the court refers to the EPTL, there's nothing in the EPTL that requires a relinquishment of the right to change one's will.
That may be true, but that's how the Court of Appeals has interpreted it, and we are bound by that. Part of the reason I noticed that it was only dicta and Aaron is I was like, oh, good, we don't have to follow that, because I share my colleague's view about your client. But then I kept reading, and I discovered that, in fact, the Court of Appeals had said just that, and I don't see any way around that. I tried to look for one, but I couldn't find it. We're bound by what the Court of Appeals said, so how can we ignore that? Is there anything after the Weitzman decision in 2008 that is to the contrary of what the Judge Saparik said so clearly in that decision?
I haven't found any case law after that contradicts that. The only thing that I can...
Then why aren't we bound by that, counsel?
Because as I stated, if this decision in the Weitzman case, if the decision were based upon lack of proof of undue influence, then anything else said by the Court of Appeals was unnecessary for their conclusion. And if it's unnecessary for their conclusion, that's the definition of dicta. I mean, he wanted, this decedent wanted to follow through. There was COVID, and life is precious, and time's a thief.
But counsel, the problem here is that the information was not relayed to the attorneys that were supposed to do the modification of the will.
I think the record indicates it was given to them, but because of COVID and the restrictions on
It was
personal
supposedly
visits.
faxed by the plaintiff.
Yes, correct.
Thank you.
And that's what the record shows.
Thank you
Right.
so much.
Thank you, Your Honor.
Let Mr. Padilla know what the court said.
Yeah,
Okay.
truly.
All right. Fields versus General Conference.
Good afternoon, Your Honors.
Good afternoon.
Andrew Van Houter from Fagry, Jinker, Biddle, and Reef. With the court's permission, my partner Brian Perryman, admitted in Virginia and the District of Columbia, will argue on behalf of appellant.
Okay, well, we will grant that application, even though I have over 100,000 lawyers right here in Manhattan, but welcome.
Thank you.
You may proceed, sir.
I appreciate the court's indulgence. Good afternoon, Justices. Brian Perryman on behalf of the Appellant Global Ministries. The motion court's order denying dismissal in this case should be reversed for either of two reasons. The first is that the court
You're just the mortgagee. You're just the mortgagee.
We are just the mortgagee, Your Honor. That's exactly right. And frankly, the mortgage doesn't actually impose any sort of control obligation in the way that a plaintiff would like it to be characterized. Even more fundamental than that, though, there is no substantial relationship to possessing or holding a mortgage on property and the sexual abuse that's alleged to have occurred at that property.
So let me start at a different place. Does Global Ministries hold the mortgages for any number of churches that are within the United Methodist Church?
Global Ministries is the repository of a lot of mortgages, not only in the United States, I believe in the world, but they have mortgages everywhere. This is not an uncommon practice, and that was evidence that was put into the record below.
You know what I need you to do is raise that mic and get closer to that mic, because I'm afraid that that it's not capturing your voice for the argument, okay?
Understand. Thank you, Your Honor. Is this better?
Yes.
Okay. So the suit does not arise out of or relate to anything that, I mean, the fact that the Global Ministries happens to be a Methodist entity, or that the mortgage happens to require that the local church be maintained as a Methodist establishment, has nothing to do with the actual sexual abuse. It's
What
not.
about the issue of church discipline? Can you address that briefly?
Sure. I think there are two issues, and I have covered one, which is that there is no substantial relationship. But to the point on discipline, I don't believe that the mortgage actually says that Global Ministries has any disciplinary authority. It speaks to the church, the Methodist Church writ large, as having disciplinary authority. And so it is not Global Ministries that is administering any discipline to the local church. It is not Global Ministries that is controlling any day-to-day activities. What you have here is a restrictive covenant in essentially a contract. Well, that alone can't establish some sort of principal-agent relationship or close control or agency relationship. So we don't think that they have even connected on the control issue, much less on the substantial relationship issue.
Is Global Ministries on the deed? Does it own the church? This particular church?
Global Ministries has never owned this church, and frankly, I'd be astonished if they owned any church. So no, the answer.
Are they essentially a holding company for the church's properties worldwide?
Holding company might be a bit strong. What they
Okay.
do is, it's a charitable entity, right? So it assists churches worldwide through a variety of evangelical and sometimes financial assistances. And so one of the things it does is holds mortgages.
Okay.
I'd be happy to address the failure to state a cause of action if the court has any questions on that.
Well, anticipating that he may hit that, you may want to say a few words about that issue.
Right. Well, even if there were personal jurisdiction, the complaint, of course, fails to state a cause of action. To begin with, the second and third causes of action for negligent supervision and premises liability impermissibly duplicate the first cause of action for ordinary negligence. They're all based on the same facts, and they seek the same damages. And under this court's case law, and under the case law of numerous other courts, that is the essential question in when you're determining whether a cause of action duplicates another one. The fact that there are different legal elements associated with these causes of action is immaterial. Courts have looked beyond that. Cause of action additionally fails because there's no non-conclusory allegation in the complaint that Global Ministries knew or should have known of the alleged abuser's propensity for misconduct.
So I'm going to stop you for a sec. The defendants in this action are numerous, right? It's not just Global Ministries?
That's right, Your Honor.
and this motion pertains only to Global Ministries and not those other portions of the United Methodist Church that may be implicated or not implicated in, by way of negligent supervision, et cetera.
That's exactly right, Your Honor.
Thank you.
Thank you.
Thank you.
You may proceed.
May it please the court, Jay Breakstone for the plaintiff respondents, and I'll take a moment to thank the court for its courtesy in my late arrival and to thank my adversary for being kind enough to allow me to do this. Okay, let's start on something which the court caught immediately. It's this concept of global ministries.
Counsel, your voice is really soft, so if you could speak louder or do something with the mic, I don't know.
That is, that's absolutely the first time anybody at a bench has told me that. But my family, which is, I think, remarkably 3 or 4 lawyers, has said that my voice has changed and it's become very, very soft. I want to remind them about all the times it was very loud and they complained. But
Just make it loud enough so we can hear you.
thank you.
Okay?
The United Methodist Church owns nothing. It doesn't really exist. And some point in the future, this court will take a look at that. It has numerous organizations.
But the question is, what is the relationship between Global Ministries and the church where your client was injured? And as far as we've been able to, as my colleague said earlier, they're really just the mortgagee. If they're really just the mortgagee, then they have no liability here. What do you claim is their relationship, and where in your complaint do you assert that?
They are not just the mortgagee.
So what do you
Because
claim
of the
they
nature
are,
of
and
these
where do you
mortgages.
assert that?
They are, well, we discuss it all over in terms of the discipline. They are the enforcer. If any church does anything that gets the United Methodist Church angry, annoyed, is against their tenants or whatever it is, Global comes in and enforces that clause.
I didn't see anything in your papers that asserted in a affidavit or a verified complaint or anything that it is the enforcer. If there is no such allegation in your papers, where does that leave us?
Well, you can take a look at page 119 of the record, which is the mortgage. And it says in paragraph, at the bottom of paragraph 1, it says that the obligations of the mortgager. Make sure that the property is kept, used, and made a place of divine worship, etc. And all subject to the discipline, and the word discipline is in bold in the original. All subject to the discipline, usage, and ministerial appointments of the United Methodist Church, as from time to time authorized and declared by the General Conference of the United Methodist Church and the annual conference within whose bounds the described property is situated. That is an open warrant to use the mortgage for the purposes of enforcing what the United Methodist Church wants.
So I don't understand. Is there anything in the record that explains how or when Global Ministries has held hearings or convened a meeting to consider charges against any member of the congregation?
Your Honor, I wish there was.
No, but
the
I'm
problem
asking you
is at this
because normally someone who holds a mortgage simply holds a mortgage.
That's right. They don't simply hold the mortgage. They
But what-
hold the mortgage
How do
over
we
the
know
heads
this?
Counsel,
of the
I
church.
have heard a lot of conjecture, but no specific facts.
Your Honor, I've got the document in front of me. This mortgage is subject to the discipline of the church, which is an open warrant to enforce it any way they want to. And the fact is,
You know, that language is really explosive, I think.
yeah, it is.
Yeah.
It is. And, I'll
And
tell
I
you,
see no basis for it in the record.
Your Honor, we're just plain.
None.
We're just plain.
But also, counsel,
We've had no
You,
discovery.
in that document refers to the General Conference as GBGM. And the section you're just reading doesn't use that phrase. So GBGM, which is the short name in that document for the General Board of Global Ministries, is not responsible under this document for discipline.
No, but the paragraph that I read to you is where the statutory, and I'm using that broadly, the statutory authority to do that, to interpret.
Counsel,
But it
I'm
doesn't
going to
give
go
it to
back.
them.
I'm going to go back to my question from before. So, for example, if does the record show that under the under global ministries, the bishops of the church convene to regularly consider issues of discipline? Isn't that in another portion of the church? I mean, this is a very, very, very large denomination with many different sections. I'm going to use the word sections. I know that that's the wrong word, but your caption reflects that. You don't have just one Methodist entity as a defendant. You have a whole bunch of them. So
They are
haven't you simply cast a very wide net that perhaps is too expansive here?
Your Honor, I don't want to cast a white net, but I don't know what's going on. I've had no discovery. I'd love to be able to ask somebody from the church what's happening. All the questions you've just asked me. But we don't know that. All we have is, I'm only gave them a mortgage. I don't know what's really going on. I work in 100 countries. I enforce. What's the word I'm looking for? More gentle than enforce, right? I implore the churches and the other parts of the mission to do what the church's work is. And I help them from time to time. And when you see this language, you go, okay, fine. You've got 100 countries. You've got 15,000 churches. I'm only interested in one. But in order to see whether or not you have exerted or have the capacity to exert the kind of pressure I'm talking about, which would take it out of just a mere mortgage.
Thank you.
Sure.
Thank you.
I haven't
You're
had
out
the
of time.
opportunity. Thank you. Your Honor.
You have 2 minutes.
Thank you. I'll be extremely brief if I can. I heard counsel say he had no discovery. That's absolutely not true. He's had over a year of written discovery. The parties produce nothing to each other because there is nothing to produce. This case is 55 years old. There's nothing. And we actually put into the record an affidavit from our historian, our researcher, who pointed out and said, under oath, there are no documents relevant to this case to produce to you here that would be relevant to the jurisdictional issue. I also like to quickly point out that the mortgage that counsel was referring to is the 2016 mortgage that postdates the alleged abuse by over 50 years. Unless the court has additional questions, I'm prepared to submit on the papers.
Thank you. Rak Lafayette Associates versus Sturm.
Good afternoon, Your Honors. May it please the court, Abraham David, on behalf of the defendant appellants. This is, in my opinion, a very straightforward case. My clients exercised their rights under a good guy guarantee. They had the tenant surrender under the terms of the good guy guarantee. Good guy guarantee was very clear on its face.
Counsel, may I interrupt you? There was a case argued in the Court of Appeals 2 days ago called 122 East 42nd Street LLC versus Scharf, which came up from this court, which seems to present the very same issue about a guarantor's responsibility under certain circumstances. So if you were familiar with this case, what I was going to ask you was whether there's any reason we should decide your case before the Court of Appeals addresses this very specific issue.
Well, I don't know the facts in the Scharf case. I do know this, that every case that I've looked at, it's so fact-specific and comma and or specific to the good guy guarantee that the subject of each case. They're not all the same. They don't all say the same thing. What it says in this good guy guarantee is clear on its face. And what it says in this good guy guarantee is that my clients had to deliver the premises, room clean, and otherwise in the condition required by the lease. On its face, room clean and otherwise in the condition required by the lease means in the physical condition required by the lease.
Right, but there's also parts of that guarantee that says the guarantor is guaranteeing, I'm sorry to keep using that word so many times, that the tenant's obligations under the lease. And under the lease, the tenant has obligations, certain obligations in terms of getting a written acknowledgement when they surrender the property.
Right, but the good guy guarantee says nothing about obligations, surrendering it with the obligations that are required by the lease. That's specifically the issue that's in front of the court.
Yeah,
I
know, yes, counsel, but as I indicated, it says the owner requires guarantor guarantee the obligations of the tenant under the lease. So then that brings us back to what are the tenant's obligations under the lease? And under the lease, the tenant's obligation in terms of surrendering would be to obtain written acknowledgement. It's not enough to just leave it in broom clean conditions or to whatever physical.
Turn over the keys, yeah.
Turn over the keys. There's more to it.
What the plaintiff argued was that in the condition required by the lease is a catch-all phrase. And my argument is that in the condition required by the lease is not a catch-all phrase. On its face, it means one thing, broom clean and otherwise in the condition.
No, that's not what our case law says, counsel. Our case law says that when a provision in a lease says you are subject to the same obligations of the other tenant that you are now taking over, that you are guaranteeing, you are subject to the same conditions of that tenant.
Right, but that...
So
sorry,
that's
Your
what that means, and there are thousands of cases that say that. This is not a unusual finding by the court.
Well, again, when it says you have to follow the obligations that are in the lease, then that's one thing, but that's not what it says over here. What it says over here,
but look at the whereas clause again, because it really does refer back to lease paragraph 25. Whereas as a condition to owner's agreement to enter into the fourth modification with tenant, owner requires that guarantor guarantee the obligations of tenant under the lease, and here's the big part, on the terms and conditions contained herein.
That's great, but that's the lease between the tenant and the landlord.
Well, that's your argument.
But the controlling document between the guarantor and the landlord is the guarantee. It is
right,
not the lease.
But I mean, I think this is the exact issue that's going to be up before, that was up before the Court of Appeals, and we'll get the answer. But based upon the case law, when we're talking about that whereas clause, it does refer you back to the conditions of the lease, and you're guaranteeing whatever the tenant's obligations were, you guarantee that.
But in every other case, there's language, at least the cases that have been cited, there's language in the guarantee that brings it back to the lease and says, you as the guarantor, on the basis and the strength of this guarantee, are subjecting yourself to the conditions that are in the lease. This guarantee doesn't have that language.
The guarantee in your case says, owner requires the guarantor guarantee the obligations of tenant under the lease on the terms and conditions contained therein.
It doesn't, Your Honor. Where does it say that?
In the whereas clause. So
the part that I referenced before.
The part that we've all referenced probably numerous times.
Right.
Yes.
It says each guarantee provided in pertinent part, and you can look at record 194 to 205.
Your Honor, the 194 is the lease. It is not the guarantee. The guarantee is on 18, record 18, 19.
Are you suggesting that every single aspect that in a guarantee, a landlord cannot refer to the underlying agreement of the actual tenant and say everything that that tenant has to do, you have to do?
I'm absolutely not saying that, Your Honor. What
Okay,
I'm saying
because
is
we
that-
know that that happens every day, right? And guarantees
Yes.
every day. Whatever the tenant has to do, the guarantor guarantees as well.
Your Honor, what I'm saying is that this guarantee doesn't do it.
It does on page record 194. That is the
What-
good guy guarantee. That's the paragraph, that's what we've been talking about.
He disagrees. Would you like, do you have any other arguments?
Your Honor, I just... Okay. Again, Your Honor, I think it's clear on its face. Your Honors, I think it's clear on its face, and I will rest on my brief.
Thank you.
Good afternoon, Paul Gruber from Borough Goldstein, Altshuler, Nains, and Goydell for the respondent.
Let me start with my question.
Let me tell you something that you really
Excuse
wanna know.
me, he's talking.
Sorry.
Does the Scharf case have a whereas clause like we have here?
I'm not sure of that, but I would like to tell the court that the Scharf case was not argued on Tuesday. The parties had settled it.
Get out.
Oh, okay. All right, well, thank you for letting us know.
Let me
Thank
ask
you.
you this.
Which
Let me
means,
ask,
of course-
let me ask you this about the whereas clause.
Sure.
So it says, the owner requires that guarantor guarantee the obligations of tenant, which my colleagues have read before, under the lease, on the terms and conditions contained herein. What does the word herein refer to?
Presumably the guarantee, however, as this...
And not the lease. Isn't there this conflict within the terms of the whereas clause? On the one hand, the whereas clause seems to be saying unequivocally that the guarantor is subject to the tenant's obligations under the lease, but then the whereas clause goes on to finish by saying on the terms and conditions contained herein, herein referring to the guarantee, that in terms of the guarantor's obligations, they're supplanted by what the terms of the guarantee say about what the guarantor's obligations are.
I think you have to look at this in the light of what Scharf did and what 9/11 Stanton did, was that you also look back to the reference to the question of whether there was a surrender in accordance with the lease in the first place, which is...
I think
because it says the tenant
I
is...
think there's, under Scharf, you're in a good position. There's no question about that. But that comes back to the question, do you have that sort of a whereas clause in Scharf?
Again, that intimate I'm not with that Scharf record, but there was a provision from what I call in the decision of this court that it made reference to something that tied in both documents.
So my learned colleague brings up a really interesting twist here, doesn't he? So to the extent that the language of the whereas clause does not say on the terms and conditions contained therein, but rather says herein, how do you parse the language?
The way I look at this is that the good guy guarantee doesn't require the guarantors to surrender possession of the premises. It's very clear that it does not. It provides that they're responsible for the payment obligations of the tenant. And the question becomes, did the tenant surrender the premises? And in order for the tenant to surrender the premises, it was more than just handing the keys back to the building manager, who the record undisputably says is only responsible for building maintenance.
So counsel, we're clear about what the tenant's obligations were under the lease.
Right.
So we don't need that part. It's the part about the whereas clause. Could you please address the difference between language that would have said therein as opposed to language that says herein, to the extent that this clause is contained within the guarantee itself?
Again, the guarantee is dependent upon the tenant's complying with its obligations as well. And it's very clear that the tenant was agreed to guarantee the obligations under the terms and conditions of the lease. And the tenant was required to voluntarily have surrendered the premises and broom clean, and in otherwise in terms of in the condition of the lease. Did the tenant voluntarily surrender the premises? Well, not in accordance with the lease. It was a very dishealed procedure.
They didn't in the sense that they had to get the landlord's written consent to the surrender under the terms of the lease. Under the terms of the lease, for the tenant to surrender, they needed the landlord's written consent. Under the terms of the guarantee, there's no mention about that except for the whereas clause.
Right.
Except for your interpretation of the whereas clause, which would interpret it to mean that the guarantor has to follow the lease as to that the tenants needed the landlord's written consent.
The guarantor has to make sure the tenant complies with the lease. That very clearly did not happen here. I see my time's up. Is there any, unless there's any further questions?
Thank you.
Thank you.
So, counsel, you must be very happy that we're looking at this particular, I don't know, would you call it a clause?
Well, Your Honors, I apologize. I did not recognize the whereas.
So let me ask you a question.
Yes.
So the lease required that the tenant effectuate the surrender in a particular way. He fails to do that in the way dictated to by the lease. Isn't your obligation, don't your obligations flow from the acts of that tenant?
No, Your Honor. When you're seeking to enforce a guarantee, the obligations flow from the guarantee, not from the lease, right? The agreement.
So let's say that instead of providing a broom clean condition, the premises was left in complete disrepair and damaged. So that it's not in compliance with broom clean condition, right? That wasn't in the guarantee?
That wasn't the guarantee.
It was.
Yes.
Okay. So my point is, can there be a proper release that you can then escape any liability on your guarantee if the tenant that you are guaranteeing doesn't comport with the provisions of the lease?
Just to be clear, the distinction between the guarantee and the lease is not something that my client was required to do. My client, under both the guarantee and the lease, was required to give the property over, surrender it in broom clean, hand over the keys, and give a notice. They did all of that. The thing that they
You didn't need the landlord's written consent.
did it.
The tenant didn't need the landlord's written consent?
The tenant did need the landlord's written consent under the lease. Under the guarantee,
There's no mention about that.
Exactly.
So under the Sharp case, depending on what the terms were in Sharp and what the terms are here, whether they're the same, the Sharp case doesn't point in your direction. Had the whereas clause under the terms and conditions contained therein, clearly you'd be in a losing position also. So depending on what Sharp says, it seems to me, if Sharp has the same provision as this, and the court is held in a way inconsistent with the position you're advocating today, you've got a problem. If the whereas clause in Sharp, if it has such a clause, is different than this, then there might be something to argue about.
I would just make one final point, and that is, when dealing with ambiguity in a guarantee, the case law is clear. Ambiguity goes in favor of the guarantor. And if we're sitting here trying to figure out what herein versus therein, what condition versus conditions means, that's the definition of ambiguous. And it has to be ruled in favor of the guarantor.
Thank you.
Or it might create an issue of fact.
Ace American versus Con Ed. And my esteemed colleague, Judge Gesmer, is recused from this case. Should there be a tie, the court will implement its procedures and vouch another judge in. Okay. Let me know who you're arguing for, okay?
Absolutely.
Go ahead.
Good afternoon, Your Honors. Appellant Integral, my name is Robert Whitbeck. Integral is a third-party defendant. A third-party defendant brought in by Con Edison. The only obligations whatsoever that Integral had with respect to the property where this fire occurred was through its contract with Diamond Rock, the building itself. There was never a contract with Con Edison, and every obligation that Integral had, regardless of whether you find that there was an applicable obligation or not, was owed to Diamond Rock. The case law is very clear that claims arising out of an alleged breach of contract can't just be converted into a tort action absent some other duty, and there was no other duty here.
Integral was the doing general contracting work?
Not the general contractor, the prime contractor at the building. They were doing a number of things, one of which was to install...
The electrical box.
No, they were not the electrical
wasn't you?
That was PSI.
PSI?
PSI was not the electrical contractor. PSI was the subcontractor for Integral that was installing a drain pipe into a wall.
It's your claim that you're the general contractor hired to do indoor work.
The prime contractor. There was a
prime
distinction,
contractor, but you're not working on waterproofing the foundation, and it's your contention also, is it not, that there's no evidence that anyone ever raised the issue of sealing or waterproofing with Integral.
That's absolutely correct, and in fact, that's a specific
And that therefore
exclusion.
there's no way you could possibly become liable to Con Edison or whoever the subrogé is, for failure to do waterproofing or stopping the water from intruding into the hotel.
Absolutely, Your Honor, and that is our position. And in fact, it's specifically excluded from the contract because there's no access to the Con Edison electrical vault. It's undisputed fact that the leak emanated from the Con Edison vault and that the leak was not fixed.
And that information came from Con Ed specialists.
From a dye test that they conducted in their own vault, and they're the only ones who had access to that vault.
And an admission against interest, yes?
Absolutely. The only other thing I would address is even if there was any ability for Con Edison to make these claims generally, and if there was any obligation as to waterproofing, the facts also make it very clear that it was impossible to waterproof the hotel side because one, Integral's person specifically testified that if you seal one side and don't seal the other side that's actually leaking, you're going to create pressure in the wall. RDA, the engineer of record, said, we recommend that the leak is fixed before any work on the hotel side is done. And just to put the cherry on top, Diamond Rock's agent, Tag, specifically told Integral, don't worry about it because Con Ed hadn't fixed their side and Con Ed was still leaking. So that certainly would be a modification.
Counsel, help me with the chronology just for a minute.
Sure.
So at the point where there's an identification of the source of the problem, how long between the time that everybody knows that there is a leak from the vault that's causing a problem and the point where there's a fire?
I believe it was at least 2 years.
I was going to ask, is it 2 years truly?
Yes, between the dye test that Con Edison identified and the cause of the fire, yes, it was that period of time. And the Con Ed witness was very direct in her answer and basically said that they had one person who handles vaults and they just hadn't gotten around to it. If the panel has nothing else, I'll...
Thank you.
Thank you.
Good afternoon. May it please the court, Nicole Galetta from Fabiani Conan Hall for PSI. Just to clarify the chronology, because I think it is important in this case. The hotel first noticed this leak on January 13th, 2011. The hotel contacted Con Edison that very same day. Con Edison sent Miss McPherson to the hotel. She came a couple of times and eventually performed the dye test that revealed that the water was in fact coming from Con Edison's vault on February 17th, 2011. Essentially, the hotel and Con Edison bickered for a couple of years about who should pay for the sealing and the waterproofing, and nobody did anything during that time to seal or waterproof the wall. My client, PSI, first started working at the building in early 2013. They were there in
Now, Con Ed makes a lot of arguments about you having created the hole.
that, I think.
So explain why that's not accurate.
So I think that's based on a misunderstanding of the testimony. There's multiple different holes in this case, and I think Con Ed.
Multiple?
Are you saying holes?
Holes, yes, Your Honor.
Holes?
Yes. So the hole at issue is the point of entry, the POE. So that's essentially a hole in the foundation wall. On one side, you have Con Edison's vault.
The drain pipe that you're supposed to connect up to, is that above the point of entry hole or?
It's a few feet
below?
to the side.
What's that?
A few feet to the side. It's not
The same level?
the same level.
And it goes through the foundation wall too?
The pipe does, but PSI didn't perform work on the part that went through the foundation wall. They replaced only a segment of the line.
You
not the
worked
whole line.
inside and were connecting up a new pipe to the line that came through from the Con Ed vault into the sub-basement?
You connected to an existing pipeline.
Exactly. But a few feet away from the point of entry. Water was only coming from the point of entry. PSI was not permitted to, was not hired to work at the point of entry. That's several feet away from the work. So I think in all this talk about holes in the foundation wall, it got missed that there was multiple different holes.
Am I understanding correctly? It's your position that you didn't do any work on the pipe as it came through the foundation wall from the Con Ed vault?
Correct.
Your work is more inside?
Correct. Con Edison doesn't permit people, contractors, to work in their vaults. We would not have been allowed to. And Con Edison, their witness, testified to that. They acknowledged that. That is their policy. We cannot touch.
So if I'm understanding correctly, Con Ed verifies and confirms that the leak is happening inside their vault. No outside workers other than Con Ed workers can go inside the vault to remedy whatever problem there is. But apparently, we're all here because somehow everyone else was supposed to remedy the problem in the vault by waterproofing the other side of the wall.
That we're not allowed to touch. Yes, Your Honor, exactly.
Okay. Just wanted to make sure I understood.
And counsel, do we have testimony, or is there anything in the record that states that in order to waterproof a wall, you got to waterproof both sides of it?
Oh, yes, that's Con Edison's testimony, Ms. McPherson.
So that even if there were a contract job to waterproof the inside of the hotel space, if the vault wasn't waterproof, that would have been for naught because the problem at the source still hadn't been resolved.
Yeah, essentially this was Con Edison's issue to fix. They were aware of it for 2 years, and we were hired 2 years after the leak was discovered, and now they're trying to point the finger at every other contractor who entered the basement. But PSI didn't touch the source of the leak.
Thank you.
Thank you, Honors.
May it please the court, my name is Dan Ratner. I represent Con Edison. I'd like to clarify a few things. First of all, Integral's general contractor, prime contractor contract specifically said that it would be responsible for waterproofing except for Con Edison's vault. In other words, waterproofing inside the hotel, number one. Number two, PSI testified.
But this waterproofing has to take place outside of the hotel, doesn't it? Because if you waterproof from inside, it'd be too much pressure.
Well, that's what one party, that's a position that one party has taken in this case, but
Do
not
you
another. There's an issue of
contend that
fact
this
there.
waterproofing, that when the water is coming in from one side of the wall, you should be trying to block the water from inside of the wall?
Well, it brings me to a different, I guess, a related point, which is that Con Edison's witness testified that they did waterproof. They sealed off the vault.
They never said they waterproofed.
They sealed the vault from outside, its vault outside. And then at that point, when there were more complaints about water coming in, Con Edison repeatedly took the position, well, you have to seal your own foundation.
So, counsel, I don't know about you, but when I was, let me think. When I was out of college and had my own apartment, I used to have leaks. I don't know about you if you had a nice place,
too.
but
Absolutely.
I had a cheapo place. And if it leaked and they only fixed the ceiling but didn't fix the leak, The leak did not go away. And actually, I would have a ceiling collapse, which I did a couple of times when I was right out of school. Now, all of us know it makes common sense. You know, it's like commonly held knowledge that in order to fix a leak, you got to fix where the leak comes from.
Well,
So I don't understand how come Con Ed is saying something that's to the contrary.
Well, then if I
of
could share
something
my,
that
if
all
I
of
could
us
share my
know.
own story, my basement leaks, and I'm still trying to figure out how. I've been told 5 different ways to fix it. That's my point. There's an issue of fact here because everyone was arguing about how to solve
Con
this
Ed
problem.
doesn't let if Con Ed doesn't allow anybody into its fault but its own people, which can make sense on many different levels, how is this ever going to be remedied? Look at it. Did it really have to take a fire?
So the Con Edison is taking the position that it sealed its own vault. But even if it didn't, it has asked for contribution by other parties who didn't do
Counsel,
what they
there's
were
a
supposed
difference.
to do.
You would agree that there's a difference between sealing and waterproofing, right? Sealing means no burglars can come in, no mice can come in. Sealing means a whole bunch of things. Sealing does not mean waterproofing.
I could just say to you, Your Honor, that nobody has offered that kind of testimony in this
Counsel-
case. There's been no experts. We're in
Counsel-
summary judgment.
Common sense.
No, well, but we are in the
Counsel-
summary judgment.
Counsel, I don't know, maybe my mic's not on before we get into that back and forth. I just want you to address McPherson's testimony in terms of how the responsibilities of Con Ed in this particular situation. They're responsible for what happens inside their vault, and they didn't do that. Did McPherson not testify to that? I mean, that's your own witness from Con Ed who's seemingly contradicting your position here today.
She took the position that they sealed the vault after they did their work. They suggested, they did a dye test. They recommended that the electric panel be moved to another location. Then the general contractors came in to do all that work. They contracted to then, waterproofing was the phrase in the contract, Your Honor, except for Con Edison's vault. They didn't do that. PSI, their witness testified when they did a drain pipe, right, it left a gap around there. Integral, there's testimony in the record that Integral was responsible for supervising PSI, but they didn't inspect PSI's work. So now you have both parties being implicated here. I understand we all want to blame this all on Con Edison. I get it. But this is summary judgment.
I don't think that you should.
The fact that you were called down 25 to 30 times before you came down, and the fact that you did do a dye test which showed that it's Con Ed's water, you know.
Well, the dye test was at the beginning
I
when
understand.
that
but,
was
you know,
the
there's some
reason for the
pretty-
project.
There's some pretty difficult facts here for Con Ed, you know.
We didn't move for summary judgment. We're asking for contribution because, you know, there can be more than one party at fault when there's an accident. We all know that, right? There can be more than one proximate cause of an accident. So, fine, Con Edison did not move for summary judgment, but we do have contribution claims here, and they're valid. That's our position. PSI and Integral both were involved here. This issue about the point of entry. There's testimony in the record that water was seen coming from that drain pipe wall. It's at pages 1394 and 1395 and 2621
The drain
and
pipe
2622.
vault, the drain pipe that was inside the vault that Con Ed
The drain
had,
pipe on
and
the
that
inside.
no one else was allowed to be inside
No,
of?
the drain pipe on the inside of the building. When they went to the basement, they saw water coming out of there. Right, very close to where the fire occurred.
So what, from your view, caused that water to come? I mean, PSI didn't even work on the pipe at that point. They worked further in.
When we go to trial, our expert's going to say it was their fault. Their expert's going to say it was our fault if you let us go to trial.
I mean, what's your theory that it's their fault when they didn't even work on it?
No, they left a gap around the drain pipe that was very close in proximity to where this fire occurred.
In going into the outer wall.
Exactly. Water was coming into the building and may or may not have come into contact with this new splice box that was created out of the old electric panel. I think that's the theory. When the experts will hash it all out, but that has not happened yet.
Thank you.
Thank you, Your Honor.
You have 1 minute on rebuttal.
Thank you.
So, counsel, your adversary says that your people left the hole, and that's the reason why the water came through.
Not only did we not leave a hole, we didn't make a hole. There's nothing in the contract that says that we were supposed to make a hole. We were supposed to replace and to install a 3-inch drain pipe. The hole was there. We were contracting with PSI to remove piping and to reconnect the piping to the Con Ed vault at that point of it.
Did this pipe traverse both spaces? In other words, the hotel space and the Con Ed space?
Well, the segment of pipe that we were contracted to do anything with would have connected to the piece of the pipe coming from the Con Ed vault that would have connected to the part of the hotel. But it wouldn't have done anything to the portion of pipe in the Con Ed vault, and that was actually the source of the leak. And aside from certainly the facts that fully support that nothing that Integral or PSI did caused anything, I just want to also point out that procedurally, everything counsel just said were obligations in a contract. There's no independent duty, and none has even really been alleged. And all of the obligations that counsel also mentioned were things that, quote, were not done, not things that were actually done. And the case law is very clear that an instrument of harm is something affirmative, not just something that is claimed that a party did not do. Actually, one other thing.
Counsel, your light has been on
I
for quite
apologize.
some time. Thank you.
Okay, thank you.
Just want to add a few quick points. First, it is absolutely incorrect that PSI said they left a hole. They did not say they left a hole. PSI said they didn't leave a hole. Integral said they didn't leave a hole. There is no evidence whatsoever in the record that PSI left a hole. All of the evidence is that they did not leave a hole. What I think counsel is referring to is PSI said that typically this work might leave a hole, but in this case it didn't because they cut the pipe before it went into the penetration, so it did not leave a hole here. There is no testimony that the drain pipe that PSI worked on, which is the drain pipe on the hotel side of the wall, was leaking. The only testimony, the only evidence is that the POE was leaking. It's simply incorrect, and it's very clear in the testimony that there was one source of water and it was not PSI's work.
Thank you.
Thank you, Your Honors.
Mikelo versus D.E. Shaw and Company. You may proceed.
Let me just adjust this. May it please the court, Jeremy Wallison for petitioner appellant Daniel Mikelo. Now, the ultimate question on this appeal is whether an employer can first hold back a certain percentage of an employee's pay and then commit an intentional tort against her or even violate her statutorily protected civil rights, and then enforce a contract term requiring that employee, that injured employee, to sign a release with zero compensation for her injuries.
Counsel, before, that's a very long question that you've, but taking that first part of that question, yes, wouldn't we have to determine whether or not this was in fact wages or something else?
Respectfully, Your Honor, no, not at all. I mean, well, the something else part, yes, but this does not, our arguments do not turn on whether the money that's held back constitutes wages under the labor law definition. For example.
No, it does matter, because under case law, one can agree to forfeit rights like civil rights. I find it outrageous, but you can, and our case law says that you can, so long as in exchange for that, you receive a benefit. And here, the exchange for that was the deferred package, right? And yes, the deferred package, again, had certain conditions, which, speaking only for myself, I find quite objectionable and outrageous, but notwithstanding that, people are free to enter into these agreements if they wish. So,
well, Your Honor, respectfully, I disagree with that. And,
okay. So the case law that we've read doesn't say what I just said.
Well, for example, our side has cited to you a bunch of cases that have nothing to do with whether the pay taken is wages or not. For example, in Ray,
But this wasn't pay. This wasn't his compensation package. This was something separate, right?
No, no.
And it was part of the law firm earnings. It was part of a pool, et cetera. Even if he made money that went into the deferred comp, it could still total at zero according to the agreement. Am I reading this? Are we talking about the same case?
Respectfully, I don't think we are talking.
So wait,
No.
there were two different terms, there are two different things we're talking about here. The profit interest, right? And then we're talking about the deferred comp. Those are two separate things. Under the profits interest and the way that was calculated, it was based upon, it would be allocated to each manager and director based upon the net profits, right? And that would be balanced at the end of the year, profits or losses, right? And so it could, depending, be zero, right? But your argument, if I understand it correctly, and maybe I'm incorrect, is that that part of it is not in fact profit interest. It's actually wages that were earned because he put in the work to earn them. But our case law in this particular, not talking about the deferred comp, but in this particular, I guess, compensation package or the way the money is, it distinguishes those payments. The Colchin case, the Friedman case, I think we have those cases that distinguish that. So why don't we talk about that first, and then we could talk about the deferred comp, which might relate to that release or whatever else.
Okay, well, let me back up for just 1 second here, which is the deferred comp piece is populated by what the other side calls profits interests, but that profits interests is comprised of the results of two formulas. One is called the strategy specific percentage, and the other is called the MD points. Now, if you look at record page 795, that explains to you how my client's compensation was conceptually supposed to work. Conceptually, my client was supposed to get 2% of the profits or losses of the specific investment strategies he managed. That's in concept. Now, if that's what he got, let's say that was just the formula awarded to him, if that's what he got, this case would be indistinguishable from Colchin's, the Court of Appeals case, and from this court's precedent in Friedman against Aronson.
Counsel, you know what's missing here?
Sorry?
And you know what's missing here? An explanation as to how and why the arbitration award was made. So yes, FINRA awarded your client a very, very significant amount of money, right? For defamation, $52 million. Okay. Your client requested a non-reasoned as opposed to an explained award. So here, where the arbitration hearing took 25 days and there were more than 18 witnesses, FINRA said at the end, after awarding your client this significant award, any and all claims for relief are denied, and the session fees were split evenly between both sides. How are we supposed to figure out all of this analysis without having the analysis of FINRA to review? FINRA, you know that arbitration awards are not easily overturned, nor are they modified. How are we supposed to do this when your person decided no explanation, I just want to have my result?
Yes, please.
Your Honor, I agree that when we're talking about a manifest disregard of the law in certain technical areas, that does present a problem. What we're talking about here is a public policy violation and an award that on its face enforced a contract provision that violates public policy. For that, you need no underlying rationale. It's on its face. And more than that, for example, we say the award necessarily enforced what our papers call the release for pay.
I'm going to give you 30 seconds to finish your statement.
Our papers call it the release for pay provision. The other side has never contested, and in fact, in its opposition papers here, concedes that but for the enforcement of that release for pay provision, they would have paid my client all of the money that he had worked for and earned. So it is the release for pay, the only reason, the only way that the court or that the arbitrators could have decided the way that they did on both contract, on unjust enrichment, maybe less so on the labor law claim, but on those two, the only way they could have arrived at that decision was to have enforced what we say is a contract provision that violates public policy.
Couldn't they have, I'm sorry. Couldn't they have also just decided give him one and take one? I mean, it could have been a compromise. In arbitration, we don't look behind what they do. So how do we know that they did what you say as opposed to compromising?
I don't even have a light anymore, may I answer? The way we know that, Your Honor, is they specifically say in the award that that the $52 million, and this is a very important point, that the $52 million is specifically compensatory damages for the defamation, not for his total claims, specifically compensatory damages. He was damaged by their tortious conduct. They awarded him 52. We're talking about the additional 14 and a half
I understand,
they took.
but, okay. Doesn't answer my question.
All right, thank you.
May it please the court, Terry Chase for D. Shaw. As Your Honor has noted, there is a very high standard when one comes forward to try to vacate an arbitration award. And as we've heard, what we're really arguing about here is whether or not there was a public policy that was at issue, that was violated. And as the Court of Appeals has told us in the matter of Spritzen, to find a public policy violation, courts must be able to make such a determination by looking at the face of the award without engaging in extended fact-finding or legal analysis. And there's simply nothing on the face of the award that would allow us to find that public policy violation. To the contrary—
But see, look, if there had not been the exchange of that benefit, asking someone to waive any rights to a claim for age discrimination, racial discrimination, equal pay, etc., is a public policy problem. You don't get to create a contract that says, you can work for me, but I have the right to discriminate against you on every single claim that the United States Supreme Court has issued rules about, okay? Now, we have case law that says you can do that in the limited circumstance where you exchange those rights for a benefit.
Yes.
That's your only out here.
Yes, Your Honor.
So it's not that the agreement that your company has, not your company, you know what I mean, your client, does not absolutely ask people to forfeit their personal liberties.
And
okay, so.
But as Your Honor notes, there is ample case law that when we are not talking about forfeiture of wages, and under True Love, there is more than a culpable justification in the record to find that this was not wages, that parties, sophisticated parties, as we had here, are free to contract and to release claims in exchange for consideration, as he had the option to do.
Right?
As he had the option to do.
And year after year, he signed those forms.
No, not year after year. At the time of his termination, at the time of his employment, he was told, at the time of your termination, you will have a choice. You can release claims or you can get these incentive compensation. At the time of his termination, he was given a release to sign in May of 2018. It was, as the face of that document says, to be effective as of that date. As of that date, he had the option to either receive $14 million, the amount wouldn't yet have been able to be calculated, but it ultimately would have become over $14 million, or release his claims. He had that choice. He took that choice. That is not a prospective release. And the fact that Mr. Mikelo's counsel has to cite us cases from Nebraska from 1906 trying to find this language to be a prospective release shows that it is not. There is no case law in this jurisdiction that says a release that tells you that you are releasing claims as of that date is a prospective release. There is also no case law that finds that to be coercive. The case law they cite are criminal prosecutions, where people are being asked to forfeit their rights in exchange for not being prosecuted criminally. There is
Counsel,
no case that says, yes, Your Honor.
Did FINRA discuss the release at all?
In the award, it did not.
Did FINRA include, consider that defamation might have been encompassed by the release?
Well, as you noted, on the face of the award, we don't know what
It's
the
not, all
rationale
right.
was. There's
The
nothing
Zippo.
there. All of this was put in front of them. They had extensive briefing on all of these topics, and they had, as you noted, 25 days of testimony.
The MD points were not based on or was it based on the specific performance of the managing director? It was based on firm profits, right?
All of these were under True Love, all of this was incentive compensation. The MD points was based upon the profits or loss of the entire organization.
The firm, not of
And
the
the-
individual.
And the strategy specific points.
So what I said earlier was correct. I wasn't talking about another case.
With
Earlier,
respect-
when I said that is precise, what you just described, I described and was told I was talking about another case.
I did not say that, Your Honor, but correct. You are correct. What you said earlier was correct. The MD points are based on the profits or losses of the entire organization as calculated after the close of the year when there is a reconciliation. They could be zero, as the documents repeatedly say, and the deferred compensation takes a portion of that incentive compensation, invests it in the funds of the organization, allows it to, again, either be vested later if there are profits or losses over a 3-year window. The strategy specific percentage is based upon the profits or losses of the entire macro group, of which Mr. Mikelo was a member. But this was a large team. He was not the head of the team. Under Beach, the decision of this first department, that is exactly the type of circumstances. We are not talking about wages. We are talking about the parties' contractual rights as they deal with incentive compensation.
So you're saying this is like deferred profit compensation?
It was profit interests, some of which was deferred, so it is both. It starts out as incentive compensation, all of it's incentive compensation.
And there was
Some of it's later.
And there's a part that's deferred compensation.
Well, some of it is then later deferred. It all starts as incentive compensation, and then it is later deferred and then reinvested. So that is then subject to risk twice. In the first instance, was there a profit in a given year? So it's at risk in the first instance based upon the profits or losses of the organization, is then at risk again when it's then reinvested in the company's funds. So this is, the deferred compensation is incentive compensation times 2. But each form of this is incentive compensation, either based upon the profits or losses of the entire organization or of the entire macro group, which is comprised of much more than Mr. Mikelo.
Thank you. You have 2 minutes.
Thank you, Your Honor. Justice Friedman, you asked about MD points, and my colleague here answered with respect to both MD points and strategy-specific, his strategy-specific percentage. The strategy-specific percentage was not an overall percentage of the macro group. It was specifically the assigned based on the specific strategies that my client managed. This is indistinguishable in that regard from Colchin's. It's indistinguishable in that regard from Friedman against Aronson. Now, let me address your point, Your Honor. You said that there was a benefit conferred here, right? And had there not been a benefit conferred here, there absolutely would be a public policy violation. There was no benefit conferred here. All my client would have gotten in exchange for signing the release is the exact pay to the penny that he would have gotten had he not been fired, had he stayed. There's no difference.
But he was only entitled to that pay if he signed the release. So you're acting as if he's entitled to it whether or not he signs the release, but that's not what their agreement said.
Let me back up for a second and put it this way. The case law that Your Honor believes provides an exception that allows D.E. Shaw to do this to their employees, all of that is case law that involves an unearned severance benefit. This isn't money that those employees worked for.
When you entered this employment with this agreement. This isn't something they put on you at the last minute as you're getting out.
There's no question about that, Your Honor. However, when you're a young person joining a company right out of college, first of all, you're not thinking about that.
Yes, but that's not an exception to the law, right?
No question. But secondly, the point is, regardless of whether you thought about it or not, it is against public policy for the following reason. If you sign such an agreement, yes, but now fast forward 3 years later, the company commits an intentional tort against you. Yeah, you signed the agreement 3 years earlier, but now, under the agreement you signed, you are required, after being the victim of an intentional tort, you are required to sign a release for that without the slightest compensation for that.
That is the bargain that he entered into upon accepting employment. Thank you.
Thank you.
People versus Alvin Suber. You may proceed.
Good afternoon, Leanna Duncan on behalf of Alvin Suber. May it please the court. Your Honors, the certificate of compliance that was filed in this case was invalid. It was deemed to be invalid on 2 different court appearances where the court indicated that it was wholly inadequate.
Could you address the waiver, the validity of the waiver?
Of the waiver of appearance?
No, of appeal.
Sorry, a waiver of appeal. I would prefer to leave that last.
Except that forecloses this appeal. So tell me how we get past the appeal waiver, which, speaking for myself, looks valid.
Sure.
So how do we even address your issue? We have to get past the waiver,
right,
to be able to address your issue. So how do we get there?
The court's colloquy in this case vacillated between the rights that Mr. Suber waived with rights that he was retaining. Specifically with regard to his right to retain counsel, the colloquy around that was particularly confusing because when the court originally spoke about Mr. Suber waiving his rights, the court included in that particular paragraph or that sentence that he retained the right to have an attorney if he chose to appeal it. After that, the court went into the discussion about what rights he waived with the appeal, but in that same discussion never clarified that he would still retain the attorney even though he was giving up all of these different rights. Although my adversary points to Mr. Suber's previous criminal history, I would like to point out that it was not substantial. Mr. Suber had 1 prior felony, 1 prior misdemeanor, and 1 youthful offender adjudication. There's no indication that he signed a waiver of appeal in those cases. And in this case, I believe that this colloquy was particularly confusing for somebody who had limited experience, an 11th grade education, and didn't have many felony plea proceedings to go by.
Counsel, turning back to the issue of the COC, and I'm going to put that, I guess, in the same context, well, not in the same context, I'm going to talk also about the motion schedule that was set. How does the people's failure to comply with the COC, particularly, I think the biggest issue is the grand jury minutes, right? How do you reconcile that with the motion schedule that was set, so time is excludable anyway, right? And even with the co-defendant's motion, even though it took them 6 months to file it, I'm not sure why that was, but the case law would say that time would be excludable. So what do we do there?
Sure, well, these are 2 separate issues. With regard to the certificate of compliance, if this court were to find that the certificate was invalid, it doesn't, all of this time is going to be charged to the people. And the issue is not just the grand jury minutes. It's actually over 64,000 documents that were being withheld from Mr. Suber at the time that the certificate was filed. That is why on 2 different court appearances.
So there was I'm not sure if I can call it a hearing, but there was certainly a discussion with the court with regard to this, and I believe that the court made a finding,
Yes, the
right?
court did make a.
That goes against you.
No, it does.
Yeah, the court said that the people
Substantially complied.
substantially complied.
They had turned over so many documents.
No, the court found that the certificate was wholly inadequate, would not survive a certificate of compliance hearing, and instructed the prosecution to file another certificate of compliance. They did not file another certificate of compliance, and they did not object to the court's findings. And they also did not turn over the thousands of documents and recordings that they were withholding from Mr. Super until 7 months after their certificate was filed. In People v.
So you're saying that there was evidence in the record that the people possessed all 67,000 documents, all of the recordings at the same time? That would be highly unusual for even the most effective prosecutor to be able to get their hands on that kind of extensive discovery straight out of arraignment.
Well, that is what the prosecutor conceded in his response papers, that they did have 64,000 pages of documents, 1,200 recordings, several different search warrants, a pen, register, and tap, emails, social media pages. This is not in dispute that the prosecution had this evidence. The prosecution's argument is that this certificate was filed in good faith, which is not the issue before the court. The issue before the court is whether the prosecution acted in due diligence, and they certainly did not. In People v. Bay, the Court of Appeals outlined the factors for this court to consider in whether or not the prosecution exercised due diligence.
I agree, and I think that the People v. Bay decision supports a lot of your arguments, but I don't believe the People v. Bay case had the same posture, right? We didn't. Was there an appellate waiver on that case? A plea and an appellate waiver? Because
The
that's
decision
the
did
issue
not
we have
speak-
here.
Right.
Right?
The decision did not speak about the appellate waiver, but there is actually more evidence here that weighs in favor of Mr. Suber than in People v. Bay. There was not a two-time determination by the court that the certificate was invalid. There wasn't a letter in the record from Mr. Suber's counsel a month after they filed the certificate saying that the certificate.
So I'm wondering then, you're saying that the court below found that the certificate itself was invalid, but then the court went on to issue a decision that mainly focused on, well, not mainly, but focused on the excludable time based upon the motion, and then briefly addressed that issue with the COC, and it found, at least there, that it wasn't invalid because that's why we're here now, right?
Sure. Well, first I want to point out that the judge that made the two-time determination during Mr. Suber's court appearance and during his co-defendants that the certificate was invalid was a different judge than ruled that on the speedy trial motion. That judge that had ruled on the speedy trial motion had only been on that case for one court appearance prior to making that motion. That motion did not have transcripts. That judge had no understanding or knowledge of what had preceded it, which was a quite lengthy history and quite voluminous discovery that the prosecution just kept on saying they were going to file a protective order, to which they never did. The judge's decision also completely leaves out the 152-day period that the prosecution took to respond to Mr. Suber's motion to dismiss. That is a preserved issue that was in Mr. Suber's motion to dismiss. He said it on the record and in his motion, and the prosecution waited almost 6 months to respond to his motion saying that they were taking too long to try the case. The reasoning for that was because they said they were waiting on transcripts which were never attached to the motion, and they never addressed that in their motion, and they never addressed that in their appellate papers. So I would ask this court to consider the information that was before this judge and that he just wholeheartedly ignored that 5.5 period. Mind you, Mr. Suber's entire period where Mr. Suber was entitled to a 6-month speedy trial period. The prosecution used almost all of that to answer his motion to dismiss. Then there is another 52-day period which the judge completely ignored the facts in the case, where there was an issue about Mr. Suber's co-defendant motion, Mr. Suber's co-defendant's counsel not filing a timely omnibus motion. I make several arguments about how that is not reasonable. They shouldn't be attributed to Mr. Suber because there were issues with that co-defendant's counsel,
But the case law would
Okay,
suggest.
I'll move on from that. But there definitely.
You have gone about 5 minutes over your time already.
Okay, if I could
So
just-
I need you to wrap it up.
Sure, if I could just land on this one part. The court's decision also ignored the 52-day period where Mr. Suber's co-defendant did file his omnibus motion, and the prosecution again failed to respond to it, for 2 months. In my adversary's papers, they say that there was no record that that Mr. Suber's co-defendant's counsel filed this motion, but it's in the record, and it's also in the transcript that the day that Mr. Suber's co-defendant's counsel filed that motion, the judge said, oh, it's in the record, it's served and filed, and the prosecution still, again, failed to answer it, which is a pattern in this case. They have failed to answer every single motion that has been filed in this case up to their own motion, their own protected.
Thank you.
Thank you.
And again, when you get back up, how do I get past the appellate waiver?
Good afternoon, Your Honors. May it please the Court, ADA Josh Weiss for the Office of Darcel D. Clark. With full knowledge of the strength of the evidence against him, defendant entered a plea to a reduced charge and waived his right to appeal. That appeal waiver is valid, tracking the model colloquy, and it forecloses review of all claims raised in his 3030 motion, including his challenge to the validity of the COC, which was raised belatedly 6 months later in a 3030 motion. Moreover, the waiver also...
Well, I mean, is that in fact true? I mean, I think that the record would reflect that the defendant was consistently saying that the certificate of compliance was illusory, right? There were certain documents that were not being turned over.
Yeah, they didn't wait until the 3030 to say that. I don't think that's an accurate statement on your part.
No, Judge, if I may clarify the record. At the court appearance a week after the certificate of compliance was filed, defense counsel stated that he believed the COC was premature because certain discovery remained outstanding. And while that is undoubtedly true, the record reflects that the parties had been in talks from the outset.
That doesn't matter. The statute doesn't say if the parties are in talk, you don't have to follow the statute. The statute says you have to have provided the discovery required before you file the COC, and that wasn't done here.
And in fact, part of the impetus behind the enactment of this statute is so that when a party is engaging in negotiations with the prosecutor, that they're aware of what the case is against them.
Yes, Your Honor. Well, I would argue that the course that the parties charted here complied with CPL 245-35, which requires the parties to diligently confer when a discovery dispute arises. In fact, in People v. Bay, the Court of Appeals said that...
I really can't even believe that you said that in this case, they diligently, in this case?
To come to terms with...
Diligently?
To come to terms with regard to a protective order before the COC was...
If you have all of the documents that your adversary said your people admitted having and still didn't turn over on time, how is that diligent compliance with the statute?
Because this was known discovery that was going to be provided to the defense so long as a protective order...
Except, once again, you keep on talking about these things that the DA's office was thinking about. We're going to move for a protective order. Until you move for it, you have to turn it over. And you can't say, I'm not going to turn it over. I'm not turning all of this over because I intend to move. You have to move.
And then when the court had issued a ruling on the protective order, there was still, there wasn't compliance with that protective order. In fact, there was some time delay and then a second chance to say, well, wait a minute, we want to ask for a further protective order.
Well, I think, Your Honor, I think it's certainly true that there was a voluminous amount of material that was subject to a protective order. The parties were working to come to an agreement. Within a few days of of the certificate of compliance being filed, they came to an agreement with regard to the grand jury minutes, but not the remainder of the discovery. Once communications broke down, the people prepared a very thorough application for protective order. It was supported by a detective's affidavit that outlined the particularized need for a protective order in this case. But understanding this court's concerns, if you're not inclined to agree with us that the certificate is valid, I would submit that the time was still excludable pursuant to 440, 34A, and D. The motion court expressly found that defendants' 3030 motion was not served until September 27th. And the prosecutor at that court appearance also indicated that his most recent email from defense counsel reflected that that motion was still forthcoming. However, even if this court finds that the motion was served on the earlier date that my opponent indicates, and that the people inadvertently failed to respond by the August 20th deadline, the period between August 20th and September 27th is roughly 35 days, which is well short of the 180-day limit required to obtain dismissal. So because of that, and above all, the appeal waiver, we would ask that this court affirm.
Thank you.
Thank you.
I would just like to point out two things that my adversary brought up. The first is, which was brought up previously, about this consensual protective order. My client did, after the certificate was filed, consent to a protective order, and then the prosecutor said that they needed to file a more exhaustive one. Even once that more exhaustive one was granted by the court, the prosecutor still took 3 additional months to turn over all of the evidence. Again, that is not disputed. In their papers, they say that all the evidence was turned over on October 14th. To get back to the waiver of appeal, just to go through the colloquy again, the court begins by instructing Mr. Suber that in connection with the appeal, if you cannot afford an attorney, you would be assigned one. After that, the court goes on directly to talk about the rights that
So would you agree, or would you agree that if we were to find that the waiver of appeal was in fact valid, then the argument is any other argument is foreclosed under 3030, or would you disagree with that?
I would disagree with that.
Is that what the case? Well, I'm sure you would disagree. What would the case law say?
I know that this court did decide recently in People v. Person that 3030 would not be, you would not be able to argue 3030 after the waiver, but I do think that it's still pending before the Court of Appeals. I think this court could address it. 3030 is a constitutional issue. My client did have a right to a speedy trial, and in this case, his violation of his speedy trial was just so...
This is a constitutional speedy trial issue in this case?
No, I'm sorry, I misspoke. I meant to say that speedy trial, obviously, it is a constitutional issue. This case, it is...
Not in this case.
Not in this case, no, but it's still just as important. My client was entitled to have his case heard within 6 months, and the prosecution took over 2 years and denied all 5 of his bail applications to be released during the height of the pandemic in Rikers during that time. And the reason why they denied his bail applications was because they said that the evidence against him was so strong, the same evidence that they were keeping from him. Thank you.
Thank you. Hart versus Scaglia. You may proceed.
Good afternoon. May it please the court, Erin Teskey with Chiesa Shahinian and Gian Tomasi on behalf of respondents Jeffrey Feynman and DDK. I'm mindful of the fact that my appellant's not here and I don't want to take undue time from the court. I just thought I would be remiss not to point out that in addition to Justice Borok's very thorough and well-reasoned and well-supported decision as a basis to affirm the holding of the trial court, there are also additional and independent bases with respect to on which to affirm the decision as to Jeffrey Feynman and DDK specifically. The claims that were dismissed against those clients are based in fraud and are subject to a heightened pleading standard. And yet, in the second amended complaint, is bereft of any details concerning what statements may or may not have been made by Mr. Feynman. In fact, all we get over and over is that Mr. Feynman said that they were equal owners, but when you actually make it to paragraph...
Feynman is the accountant, right?
Correct.
And he is the one who produced each year tax forms that stated that.
So if you,
right?
That's right. So if you actually look to paragraph 77, which kind of cuts out the snippet that she's referring to, it says that, and you read the top of it, and it's a little hard to read in the complaint, but it says that list here any shareholders which are either 20% or more owners or have directly or indirectly hold 50% or more of the voting shares. And then if you look at it, it identifies...
So is Mr. Feynman denying that he repeatedly told Ms. Hart that she was a 50% owner of FHI?
Correct. So if you look at that
He's
text...
denying that.
He does at any point before I think the statements that were actually made
So
were...
on June 12, 2020, Feynman has an out because at that point, the plaintiff is signing a document which reflects that she's not an owner of 50%, and she signed it, she needed to read it. But until June 12, 2020, why isn't why, and this is a pleading motion, let's remember, why doesn't Feynman face exposure based upon the allegation that he did assure the plaintiff that she was a 50% owner?
So if I could just make to answer that in two different ways. So the first is that the statement that she's actually relying upon doesn't say what she claims that it says. What it does is identify that first of all, it's a tax filing, so it's intended for the state to rely on in terms of how much tax liability there are for the parties. So it's not intended to tell the plaintiff
But those tax filings had application to the plaintiff also, did they not?
They do, Your Honor,
Was
but
she
they just...
aware of them?
Yes, I understand that she was. They were not intended for her reliance to show that she...
It doesn't matter what they were intended for. It said she was a 50% owner.
And why couldn't she rely on that, whether he intended it or not?
Sorry, I want to go back to that because there was a second point there. But what the statement that actually shows in paragraph 77, it states that they were both, it shows percentage of voter control shares, and it says 100, 100. So it doesn't even say that they were each 50% owners. It says 100, 100%, 100%, which is very obviously not saying that they both own, each of them does not own 100% of the voting shares. That's not what that's intended to relay.
So I have a plaintiff who says her trusted accountant, who she knew before, it was her friend, right? Wasn't he her friend?
I don't actually think that...
Oh, no, now he's not her friend. Okay. I like that. That's even better, right? So she has complete trust in him. She knows him for a long time. And he says to her, don't worry. Go ahead. You have 50% of this company. And I know that your client is denying that, but I have a plaintiff who says that's exactly what happened.
But I don't think she actually makes that allegation in the second amended complaint. She alleges that he says that they were equal owners. And then when we actually get to the point where
so equal owners means we own the same amount. In my book, equal means the same.
Yes, and the inference there is 50-50, right? But when you actually get to the paragraph 77, which is the only paragraph that has any context saying that what he actually said or the details around what he said, it says that they each, next to her name, it says 100%, and next to Mr. Scaglia's name, it says 100%. It's obviously not saying that they each own 100% of the company. That's, and he explained this in a deposition.
So obviously not saying if one has voting control and the other one doesn't.
Right, I don't think that you can take that line item.
I mean, in context, in terms of a pleading motion, wouldn't it be fair to say that this led the plaintiff to believe she's on the same footing as the defendant?
I don't think that that's a reasonable interpretation.
Really, because I'm going to lose my job as a CEO of one company that you sold, my future husband. And then you put me in charge of another company, right? That you tell me, yeah, you know, you're 50% owner. So you should be CEO without pay and without an employment contract. And she's told by her fiance, then her husband, that that was the deal. And her friend, the accountant, says, don't worry, you're 50% owner. So I don't understand how that's not actionable.
Okay, so two things. One, I don't actually think that's what she's pleading. What she's pleading is that he said that they were equal owners, then they have that tax statement. But setting that aside, because we don't agree on that, she is the only way that you show that you can plead fraud is that there was some sort of reliance on that statement. And for a year,
She didn't get paid.
but except that
She was a CEO making $1.5 million for the other company, but out of the goodness of her heart, she chooses to become CEO of FHI for $0.
So two things. She did that knowing that she was not a shareholder. When she accepted those terms, she understood that she was not a shareholder at the time she was not a shareholder.
Counsel, is there a fiduciary relationship by Mr. Feynman, the accountant?
There is not. There is
plaintiff?
not. The Friedman versus Anderson says that there is no fiduciary, generally there's no fiduciary relationship between an accountant and their clients,
But you
unless
don't
there
need
is something else that gives
a
rise.
fiduciary relationship to uphold the first and second causes of action against Feynman, do you?
You need a fiduciary relationship for the fraudulent concealment piece because there has to be some duty to disclose this information or some disparate knowledge base between the
Well,
two
isn't
parties,
that-
which there's
isn't
not.
that present here? Disparate knowledge?
There's not, because she was she was the CEO. She had access to the books and records. The information, this information is publicly filed with the state. She could have at any point in time, with the smallest amount of due diligence, determined this for herself. And in fact, when she asked Mr. Feynman, what are the
She doesn't have the
paperworks-
right to trust her fiance, her husband, and her accountant.
Well, her fiance maybe, but I'm not here
So
representing
that's
him.
the question.
When, as soon as he,
Do these relationships excuse her from the need to make that check of public records? I mean, if she had a right to rely on her accountant, who's also a friend, and her husband, or soon-to-be husband, does that excuse her not having checked? And I know it's your point, they could have gone to the certificates of incorporation in Delaware and seen just what was going on in the amended certificate of incorporation. But was she excused from that, at least until June 2020, because of this relationship?
she's not. So there is no heightened duty here and so she's not excused from that. But as soon as she asks Mr. Feynman for the documents that show their relative ownership, he immediately responds with the relevant documents, which on their face show that she is not a 50-50 holder.
Scaglia has chosen not to oppose this appeal.
Yes, yes. But as soon as she asks, and by the way, we have on the record, the Delaware court found that she knew as soon as she received those documents, she sent them to her attorney, and her attorney told her
In June 20.
unequivocally, you own less than he does. And what does she do? She continues working for free under the exact same terms for over a year. So how does she show reliance? She's going to say, oh, I wouldn't have done that. Actually, we know what would have happened. She did do that. For a year, she knew exactly the circumstances she was in, and she did the exact same thing.
Thank you.
Thank you.
Okay. Last but not least, People versus Ba.
Good afternoon, Your Honors. May it please the court. I'm Sarah Vinzulis, the Office of the Appellate Defender, appearing on behalf of Lamrana Ba. Mr. Ba was surrounded by 4 men who were angry and shouting at him. The jury could easily have found that he acted in self-defense when he pulled a small razor blade out of his pocket and held it in the air. But the court refused to instruct the jury on justification, relying on arguments from the prosecutor that just displaying the tiny blade was a use of deadly force.
Counsel, the issue about razors being tiny doesn't really fly over here. Razors are sharp and they can kill you pretty easily, maybe because they're tiny. Was anybody else armed?
No, Your Honor. However, the only witness was asked whether the other man who Mr. Ba was in the confrontation with when he arrived on the scene, whether it was his testimony that that man had nothing in his hands, and he said no, he didn't know.
Were any threats made?
Were any threats made
to the defendant?
Mr. Ba? No, no threats were made, but the threat of physical force was certainly present in this confrontation by the fact that these people, well, first of all,
Everything was verbal. some differ about that as to whether or not they were saying, move on, get out of here, leave a young lady alone. But let's assume there was still a verbal argument. No one had touched him, moved aggressively toward him. It was this this razor rather, that was pulled out by your client, right? So that would make him what, an initial aggressor?
Yeah, so I think the question that you're asking is whether you can ever, bring a knife to a fist fight, or whether you can ever, as my opponent says, produce a blade in response to an argument that where your opponents are unarmed.
Is that really the question, whether you can bring a knife to an argument, or whether you can wave it or swing it about?
I'm really glad you asked that, Your Honor, because the testimony is actually very clear that Mr. Bott did not wave or swing the blade. Joel Reese is asked multiple times whether he swung it, whether he prodded with it, whether he jabbed with it, and he answers every single time, no, no, no.
The question was whether he attempted to like strike anyone with it, no, but he pulled it out.
Yes, Your Honor.
At the people he was arguing with.
Yes, there's no dispute that he pointed it in their direction. From a
Okay,
distance
well,
several
that
feet
is a
away.
threatening gesture at the very least.
Yes, it is, and
right?
it makes out the crime of menacing.
So in response to an argument, he pulls out a weapon to...
Yes, in order to get them to back off. So again, these people are within several...
Was there any evidence that he couldn't walk away? That he was surrounded and prevented from leaving, as you are required to, if you can, before you can get a justification charge? So is there anything in the record that says the people he was in a quote-unquote confrontation with were surrounding him and preventing him from leaving?
Actually, I do think that the record is indicative of him being surrounded, because he has the one man who he's fighting with on one hand, and then he has these construction workers and Mr. Reese who come, and they come within feet of him. They testify that they approach him, and they come within feet.
This is happening right in front of the restaurant.
Yes.
Restaurant to be, right?
That's correct. So he is surrounded, and again, his use of the blade is purely defensive. He's holding it. He's not swinging it. He's not jabbing it. He's saying, "Try me." In other words, he's saying, if you come any closer, if you attack me, I will use this. But he is.
But he had said that to the other person he was arguing with prior, right? So he seemed to be on a roll, as it were. Okay, so he seemed to be combative with anyone who engaged him.
Well, also he's responding to a threat that we actually don't know what happened beforehand. We don't know if he'd already been hit. We don't know if he'd already been shoved.
No, we do know that because there was no evidence of that.
Well, that's true, but the court was obligated to look at the evidence in the light most favorable to Mr. Bott. And what we do know is we know that there was an aggressive confrontation between two men. They had an apparently antagonistic relationship. We know the other man...
Aggressive? There was an argument?
We know the other man was shouting. We know the other man had his hands up.
Does shouting mean aggressive?
We're in New York. People talk loud in New York. So I'm told I talk loud all the time. So,
So we have to be fair, it is an ambiguous record, but we have Mr. Bott being surrounded, and we have Mr. Bott being approached at a very close distance. We have a man who's larger than him, who he has this prior relationship with, according to Joel Reese, who's shouting, who has his hands out, who may or may not have something in his hands, and then these two other strangers join the confrontation. They're construction workers. Who knows if they have hammers or things, they're not carrying them, but they might have them in their belt or whatever.
Oh, there's so much manipulation here. Wow. This is
Thank you. You'll have time on rebuttal.
Thanks.
May it please the court, Alex King for the people. Defendant was not entitled to any justification charge.
Is there evidence that he was surrounded?
No, there was not, Your Honor. No evidence whatsoever. As to the justification defense, we know that that defense is unavailable for defendant's crime of conviction as a matter of law. But even if it were available, there was no reasonable view of the evidence on which defendant was justified in threatening any force, let alone deadly force, against people who were unarmed. As to the distinct but related intent and justification charge, if there was no reasonable view of the evidence on which defendant was justified, which there was not, it would only have confused the jury to include a charge about justification. So the jury could not have been misled by its absence.
So I'm kind of intrigued by a couple of things. Several of my colleagues have asked whether there was an opportunity to retreat, whether the defendant was surrounded. I looked at the record, and the allegation is that he pulled the razor out of his pocket and removed cardboard packing that was around it.
Correct.
Could you comment on that?
Yes, Your Honor has accurately stated the record. There is no evidence to suggest that he was surrounded. There is no evidence to suggest that he was not able to retreat. This was out on the corner of Broadway and 30th Street or so. At 9:45 in the morning, he was not backed up against a wall. He very well could have left, but instead what he decided to do is take this razor blade out of his pocket, tear off the packaging, and swing it at these unarmed people. You cannot do that in our state or anywhere as far as I am aware, and for that reason, he was not entitled to a justification charge.
Thank you.
Thank you.
Counsel, you have a minute.
Just to go back to the surrounded issue, Your Honors, Mr. Ba, there is some evidence that he was surrounded, and that is that initially he's confronting the other man. The two of them are in an argument, and then at that point, Joel Reese testifies that he turned. So in other words, they were behind him. So you have someone in front of you, you have someone on the side of you. That we don't know exactly where everybody was standing, but again, this is it's the prosecution's burden to make this record that he was in this. That he was not justified, and that they did not do that. They did not put any of this evidence on the record. My adversary just said, "Oh, he was not backed up against the wall." That is absolutely nowhere in the testimony. It's not fair to make that statement today. Again, there was a reasonable view of the evidence that he was justified. As I've already said, it was many people close to him, within 2 feet of him. He doesn't know them. One of them he does know. One of them is scary. And then finally, he did not swing it. If you look at the testimony and you look at the evidence, it's very clear that he did not swing it. He was asked whether he swung it, and Reese clarifies that he did not. With that, for those reasons, we ask that the conviction be overturned. Thank you, Your Honor.
Thank you so much.